never slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast. I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains at last, and to believe in what you got, it was built to last, yeah.
All right, everybody. So we are here for an emergency Justice Watch Live episode 15. Obviously, tonight we're going to be talking about a lot of things here because we have some big news coming out of Marathon, Florida, and that is that Judge Morgan has issued an arrest warrant for Franklin Tyrone Tucker. He will be potentially in custody within the next 24 hours is what the reports that we're getting. We're going to go over all of it. We're going to go over some things that I've found. I'm not sure how I missed these things originally, but we're going to uncover this thing, and we're going to talk about the biggest fear that Tyrone Tucker has right now, and we're going to put it out there, and I'm going to ask anyone who comes across this to share this, put this out, send it anywhere, because it's a matter of life and death at this point for Tyrone Tucker. Bottom line, when he goes back into custody, it is going to be up to us, up to the media, up to people to keep a light shine on his case so that he can make it out, not just with his freedom, but with his life intact as well. Because what I'm going to share with you tonight is something we missed over the last few months about the judge. This is something I believe was set up. This has been a setup from day one. Judge Morgan is carrying Judge Jones' water, and he is leading Tyrone Tucker to his execution. And I don't mean in a courtroom. I'm talking about getting him down into Monroe County Jail, and we are going to talk about the unexplained deaths that have happened and occurred in Monroe County. I'm going to show you a site that you can go to yourself and see. Someone was documenting this. It's been documented in court cases. And when he enters the Monroe County Detention Center, if no one is paying attention, he may never come out. And you see for yourself some of the disturbing things that have been going on. But it is imperative that the community that's built up around his innocence, if you've watched my videos, we need the help now. We've got to make sure that this case does not get lost, because they've made a move on him, and it's very serious. This is like something out of a bad movie, but it's real, and it is very, very, very serious. And while it's become interesting on YouTube and everything because he's made himself available for interviews, it's now become very, very real. And these prosecutors that are down there, there's some terrible, we're going to go over all of it. They're filing for a gag order. They've rehired the prosecutor who was suspended by the state bar twice. One for another case that was not involving Franklin Tucker, and another for her actions and behaviors in this case. And Dennis Ward went and hired her back. This stuff, you can't make it up. It is absolutely startling. And there is nothing more important right now than uncovering all this. Yep, Hawk. So here we go. These judges. How you doing, Cam? Well, the thing is, Hawk. Yeah, that's exactly what I'm going to say. I mean, we've got to get the lawyers back involved in this because it is at a point now where there's no way he's going to be able to continue defending himself, in my opinion, from a jail cell in Monroe County Detention Center. So he's got no choice, but in my opinion, but to bring them back in. And we're going to talk about that. But first of all, let's get into the first thing here that we're going to talk about, and we'll get into the announcement today that came through on Tyrone Tucker's Facebook. So let's get into it here and get caught up to speed. So here is what Ty posted earlier today. I'm not. We're just taking straight from Ty himself because that's the best place to get the information. So he says, to all, I guess I was wrong about the judge, and I had a bad feeling. If you listen to my hearings, and we're going to get into some stuff that I found. I don't know how I missed this in my initial research of the judge, but it's shocking. But anyways, to all, I guess I was wrong about the judge, since he just issued a warrant for my arrest for supposedly missing a urinalysis that I did not miss. I went and was told I couldn't take the test. Pre-trial even checked with the facility to find out the issue, and I then took the test. But now I get a warrant while in compliance. To make it even better, he wants $3.1 million bond to keep me out of jail. So what they've done, remember, his bond had gotten lowered to $100,000. And now they're increasing it to $3.1 million. Remember, this is unheard of in a sense, because this is a guy who went to trial and it came back, and the jury came back hung, meaning the presumption of guilt is lessened when that incident happens, that he went through one trial already and it wasn't successful. So this guy's been out on bond for 5 years. 5 years he's been out on bond. 5 years he's complied. And this judge, over a urinalysis, is going to increase his bond to $3.1 million. They're increasing it to a point that's going to make it hard for even his wife to post a bond of that size. That is a lot of money. $3.1 million. Okay, cash bond to get him out of jail. That's what this judge is doing. Even if this is a mistake, it doesn't matter, because I'm sick to death of being treated like a criminal and having to worry about going back to jail whenever I fart and cough. But these asshats with no evidence lied to the jury blatantly on national TV, and yet still, months later, it is yet to be addressed. Maybe if he hadn't lied, I would still be on pretrial release, which I should have never been on in the first place. But this move is absolutely ridiculous. Right now, I'm not sure how I want to handle this, because it's obvious that this guy is going to be just as bad as the last, and I refuse to be railroaded into a crime I did not commit by a bunch of corrupt bastards who wiped their ass with the Constitution. So I guess this is a reality check on getting any kind of fair trial in Monroe County. Furious is not the word for what I am right now, and it looks like my only hope is if I have enough of you file a complaint with the Department of Justice, who have already accepted my complaint but seem to be sitting on their behinds and letting this go down. So here's the link to file a complaint, and my report number is 350-487-GNV. Please tell them what you've seen and what is happening, and I thank you all for supporting me in this fight. I'm sorry, I will try to do another video so that we can talk before they arrest me, but I need to finish a few things and prepare to be returned to jail. I honestly can't believe this is happening to me, but the Department of Justice will do something if they get enough people telling them how wrong this is, because it sure as hell ain't justice. Love you all, Ty, DOJ. So that is what's happened so far. But the fact that this judge pulled the trigger on this, we knew he wanted to do this because, and this is why I was leery of him, because he told Ty in not the last hearing, but the hearing before, he said, I already issued a warrant over the battery failing. The ink is still not dry. Mr. Tucker, don't step out of compliance in any way whatsoever, or I'm issuing an arrest warrant. And sure enough, that's what he did. Now, at that time, we didn't know about this guy. We didn't know what this guy was about. We didn't know. I'm going to share with you some information now. And I need to make sure that when I pull this up, hold on a second, guys, because there's a picture of this gentleman's family, and I'm not putting that out on the internet. That's just not going to happen. It's not how we do business here. Justice is a process. that goes with this article. So I hope I have it lined up, and I think I do. Let's see here. Is that it? Yeah, no. All right, so I'm going to share this tab. I'll make sure this thing is lined up. So this is an article from November 8th, 2021, when this judge was sworn in. Now, I don't know how I missed this article. I don't know how I didn't see this article. But this is extremely significant because I want you to see who swore him in and who recommended him for the judgeship. And this is going to blow your mind. On October 27th, Monroe County's bench gained its newest judge as Jimmy Morgan, that is the judge in Ty's case, was sworn in by Judge Mark H. Jones. Who is Mark Jones? That was the judge who just recused himself on this case. Okay, so the individual who swears him in to the judgeship, who he has swearing him in, welcoming him as a judge, is none other than Judge Mark Jones. And it is this judge, this gentleman, who takes over this case. Okay? And again, I didn't trust this guy from the beginning. Something didn't seem right about him. I didn't like him. I didn't like the way he was coming in. I felt like his role here was to come in, and he walked Ty in and waved that right he waived his right to be tried again, the speedy trial, and he walked Ty right in and waved that right away, and he shouldn't have done that. That should have been left open until the very last moment. It needed to be, but he walked him in, waved it, and got him out of there. I did not like that at all. This guy just seemed like something was off. Now, let's move on into this article. I always identified him as an outstanding person, not just as a lawyer, but as a human being in terms of his character, his commitment to duty, and his diligence, said Jones. That's what Judge Jones is saying about this guy. He is glowingly endorsing him and endorsed him for the judgeship to get appointed from Ron DeSantis. That's who they put on Ty Tucker's case. If that ain't hometown cooking, if that ain't rigging this case, nothing is. And then he ends up being the one who ends up coming into this case and revoking Ty Tucker's bond over a urinalysis. This was set up to have this happen. Judge Jones was afraid to do it because he'd come under such fire in the trial. Now, a graduate of the University of Florida's Levin College of Law, Morgan said he had a history of service from a young age. A former student body president in high school and fraternity president in college, he served more than 8 years with the United States Marine Corps as a prosecutor upon graduation from law school. Now we can remove this black box here because we're out of the area that I want to block out. When I graduated from law school, I had always been in awe of those who had served our country, said Morgan. And I thought maybe I should just stop admiring these guys and do it myself. Morgan credits his time in the Marines and mentorship from senior officers as experiences that helped to shape him and provide a genuine sense of nature of justice. He enjoyed learning the prosecution function as he was tasked with special victim cases. A lot of those victims were the voiceless, said Morgan. You're able to be the voice for them and find some measure of accountability. After resuming civilian life, Morgan took his first opportunity to head to Key West, where he joined the public defender's office. Now understand this. Where did Judge Jones come from? The public defender's office. Okay, so he goes right there following Judge Jones' tract. Now, let's continue on. I thought if I'm going to learn the defense function, it would be interesting to serve those who truly can't afford legal representation, people who probably need the protection most, he said. Even with a prosecution background, Morgan said, he came to love defense work as well. It was a commitment to service, but I also had great peer mentors who were closer to my age. When you spend time in both the prosecution and the defense function, you get an idea of what it's all about. It was in Key West that Morgan had the opportunity to practice in front of Jones, who served as chief judge at the time. Being a judge has always been a dream of mine, and Judge Jones used to say, each and every case rises and falls on its own merits, said Morgan. It's not one size fits all. Each case has its own factual scenario and different people. You have to look at all the factors. You just have to. It always felt like Judge Jones arrived at a true sense of justice. This is the guy who has taken over the case from a judge who has railroaded Franklin Tucker at every angle, every place he can. This is Judge Jones' mentee. Judge Jones is his mentor. Judge Jones is the judge he wants to be. Judge Jones is someone he holds in high esteem. This is the guy that Ty Tucker was recently thinking was going to come in and reverse Judge Jones on his motion to dismiss. Obviously, that's never going to happen. That's who they brought in. This is an individual who carries the water of Judge Jones, who owes Judge Jones for his judgeship. After gaining experience on both sides of the courtroom, Morgan said he found himself anticipating and predicting the outcome of cases, whether or not they were in his favor. It was at this point that he believed he was ready for the next step. There comes a point when you're looking left and looking right, and you say, okay, I kind of get it. You have to put yourself in the best position to move on to the next phase. I invested time and energy and effort in learning one skill at a time, and I feel like I did that. By his own estimation, years of experience in both prosecution and defense, coupled with Marine Corps training that allowed him to make decisions under duress while on active duty, prepared him for the challenge of presiding over cases. In the Marine Corps, lawyers are line officers, and they can take command of Marines and go into combat. I was a decision maker. When appointed by Governor Ron DeSantis, Morgan was thrilled to accept the new position. It was a true honor to receive the governor's appointment, and it's great to be sitting on the bench alongside the judges who serve Monroe County. I repeat, it's great to be sitting on the bench alongside the judges who serve Monroe County. These are some great people and great lawyers here who've committed themselves for decades. Does that sound like somebody who's entering into a case that has the potential to take down the entire legal structure of Monroe County, a case to which could lead to the Justice Department coming in and cleaning house? Does this sound like a guy who's coming in to help Tyrone Tucker? Absolutely not. And given what we've just seen, the first move he makes is revoking Tyrone Tucker's bond, returning him to Monroe County Detention Center. That is a strike against Tyrone Tucker. That is designed to discredit him at a minimum, and it is designed to potentially put him in harm's way when he gets back down to Monroe County. And we're going to discuss that part in a minute. But this man was not brought in to help him in any way. And if you think this guy could possibly be impartial, when Judge Jones is the individual that he respects the most, is the man that led him to aspire to be a judge, then you're fooling yourself. I don't know how I missed this article. Now, here's the other thing that you need to know. When you get appointed to a judgeship, the law of Florida says to maintain your judgeship, either within 2 years of the appointment, you have to go before the voters, or at the end of the 6 years, a judge has to go back before the voters and continue to be voted in. If he isn't voted in, he's thrown out, and then the governor gets to appoint a new judge. So, in this case, at this time, in this year, 2024, he has to go before the voters. Hence, why Judge Morgan is saying this case will be tried by the end of 2024. Because he knows he has to return to the voters. He's been told, if you want to get elected, if you want to continue to be a judge, they got to take care of the biggest problem right now, the biggest problematic case that they have in Monroe County has got to be solved by this young, aspiring judge. Hence, why he's made it clear to Mr. Tucker that he's going to put him in trial, take him to trial again. So, what does this tell us? What should this tell Tyrone Tucker? Whatever the issue is that's preventing you from involving your attorneys, it's time to bring them back. You are not going to beat this judge and alone. And you will not beat this judge you will not beat this judge alone in the Monroe County Detention Center. That's impossible. That's an impossible feat. That's an impossible task. It's not going to happen. And Cam says, sounds like a paperwork issue. The court should check their info. Well, it does, Cam, but here's the thing. I think that when you couple that in, if you're still watching and you've seen this, what I've just shown you, you're going to understand it's more than a paperwork issue here. This is not just a paperwork issue. This is a strike out against Tyrone Tucker. This is the first of many that's going to come his way. This is the way they're going to. Remember, they get him into the detention center. Say he survives. He's now back there where they can, again, move another prisoner in and claim that he heard a confession or he overheard Ty Tucker confessing. Remember, they already tried that. Naheem Jackson. I haven't got into it yet. There's so much to get into, and I'm trying to cover other cases and do lots of different things, and then YouTube takes away my monetization, so I had to go other ways to try to also drum up money. So, but bottom line is, Naheem Jackson. Naheem Jackson is an informant. We're going to try to get into as much as we can. Naheem Jackson is an informant. Naheem Jackson was brought in by Colleen Dunn because Colleen Dunn just got rehired. You should have seen that. That's also something else. Let's go back to Tyrone Tucker's Facebook page because he posted. Share this tab. Hold on here. All right. So there it is right here. So here he posted this story right here. Keys News. Share this tab instead. Let's go in and talk about it. State attorney, and this is confirmed now, guys. I had talked about this before, and it is now a confirmed thing that Monroe County State Attorney Dennis Ward has rehired a prosecutor who resigned several years ago and has been twice suspended by the Florida Bar in recent years. The Florida Bar last suspended veteran prosecutor Colleen Dunn for comments she made via text in attempting to block the marriage of one of the Treehouse murder suspects, Franklin Tyrone Tucker. Dunn signed a consent decree with the bar, which handed down a 15-month suspension that started January of 2022. Dunn previously signed a consent agreement with the bar in the Florida Supreme Court in 2020, approving a one-year suspension for not divulging evidence in a 2010 attempted murder case in Monroe County. Dunn resigned from the Monroe County State Attorney's Office in December 2019 after she entered into the consent agreement with the Florida Bar in that complaint. Ward does plan to have her start prosecuting cases immediately. She served her suspension and she is coming back. I have every confidence in her. Like, if this doesn't resonate with you, with anyone who sees this, Dennis Ward is hiring back a prosecutor. That 2010 case had to do with her not disclosing information to the court in regards to a jailhouse snitch. The same thing she did with Colleen Dunn or with Tyrone Tucker. And that's the reason why Mark Jones eventually granted Tyrone Tucker bond. So he was out on bond because of that. And in fact, we're going to go back and we're going to, on this topic, I'm going to share this with you. I don't know if anyone's seen the entirety of this, but we're going to read this into the record right now. Why is that, Cam? Why is that? Oh, for his actions during trial. Well, and is that the prosecutor in that case? Or is that the defense attorney? Dear Judge Jones, I'm sure my attorneys would strongly advise me against writing this. This was written August 29, 2019. I want you all to know this. Tyrone Tucker sitting in jail. He writes this letter. This letter sets in motion the IA investigation, sets in motion all the things that have led to the documentation that we have, to Penny Phelps getting fired, to Danielle Malone getting reassigned, the pitcher getting reassigned, and to Colleen Dunn eventually losing her job. So, this is a very important letter. I'm sure my attorneys would strongly advise me against writing this letter, but I recently received a copy of the transcripts from the August 1st hearing and felt it absolutely imperative that I respond to your comments made at that time. If I may refresh your memory, the state attorney, Ms. Colleen Dunn, was in the middle of an overly dramatic series of lies to the court about how the sheriff's department has been unable to locate Ms. Anathea April Clay. Admittedly, it was inappropriate for me to roll my eyes and chuckle, but in my defense, I feel I have endured way more than enough dishonesty from Ms. Dunn. At that point, you asked, is there something funny? And I apologize, but you continued to chastise me with, I don't understand why there's emanating over here this constant drumbeat that they're cheating, they're devious, the state is. I interrupted you by saying, because it's obvious, Your Honor. You responded, well, sir, it's not obvious to me. Furthermore, it's the tone of the defense for this particular defendant, but I don't find it to be helpful. I don't find it to be based on anything I've seen so far. You continued saying people can litigate vigorously without constantly accusing the other side of cheating, lying, breaking the rules. That's really not appropriate, and you ought to really have some darn good reasons to do it before you just throw around those accusations. This particular comment is the one I find most disturbing and truly infuriating to hear coming out of your mouth. You, the man who has held me hostage for 2 years, ruling that guilt is evident, with absolutely no evidence other than witnesses with zero credibility and every reason to lie. While you choose to ignore all exculpatory evidence, I know I am innocent, and felony murder is one hell of an accusation, Your Honor. So where are your darn good reasons? If you remember correctly, the exchange ended with me stating, we have proof, Your Honor, an accurate assertion that you chose again to completely ignore. You also chose to ignore my attorneys challenging Ms. Dunn with these blatant lies and her providing no response to the allegations. You didn't even question why the sheriff's office and the state would engage in protecting Ms. Clay from inquiry or possible prosecution. Could it be that they are afraid of headlines like MCSO CI sets up robbery homicide and goes free? Or even better, sheriff's department involved in setting up then covering up the treehouse murder? Either way, the purpose of my letter is not to further implicate the sheriff's department or the state attorney's office, as there is already a mountain of evidence proving the numerous acts of misconduct committed by both of these parties. However, unlike them, we are not relying on professional perjurers or lies coming from the mouths of murderers in order to prove our claims. My defense team and our investigators rely on facts, not fantasy, which brings me to the facts concerning your own acts of misconduct, Your Honor. Forget about the fact that you have a clearly prejudicial bias favoring the prosecution and that you feel it's necessary to argue their case for them while allowing gross malfeasance. Forget about the fact that we've totally destroyed any concept of due process and have disregarded every bit of case law, state statute, or even the U.S. Constitution when making your decisions. The reason I say forget about the facts is because all of these transgressions can be explained away by excuses of poor judgment, misunderstandings, or varied interpretations of the law. However, there are absolutely no excuses for the events surrounding the May 3rd, 2019 hearing regarding Austin Odom. As I'm sure you're very well aware, Austin Odom is listed as a prosecution witness in the case against me. At this May 3rd hearing, you conspired with Kevin McCarthy and Patrick Flanagan to allow a plea deal that highly encouraged and incentivized this witness to leave the state of Florida. Now, I'm sure it's not obvious to you how this is considered cheating or breaking the rules, so let me explain it to you very simply. Kevin McCarthy works for the Public Defender's Office, which is a conflict of interest, but he was still at this hearing representing Mr. Odom. Even worse, Mr. McCarthy also represents Mr. John Johnson, a co-defendant, who just happens to be testifying against me. I do find it odd that the transcripts for this hearing say Mr. Odom is represented by Patrick McCarthy with a fake email address listed. It's almost like someone was trying to hide the fact that Kevin McCarthy was his attorney, but that's probably just a mistake, right? It's also probably just a coincidence that the state attorney was Patrick Flanagan, a man who has recently taken a much more active role in my case and was even present at the hearing, which prompted me to write this letter. Rumor has it he is preparing to take over the case after Colleen Dunn has her license suspended for misconduct that is noticeably similar to the concerns we've raised, but you, quote, don't find to be based on anything you've seen so far. As I stated earlier, we don't need rumors because the fact is we have 3 people at this May 3rd hearing, a judge, a public defender, and a state attorney who are all directly involved in a homicide case, who all knew this man was a witness, and yet conspired to have him leave the state. No mention of the defense or depositions or even how you intend on getting him to return for trial. Just leave. So are these darn good reasons, Your Honor? Can we start throwing around accusations like misconduct or witness tampering, ironically a felony charge for which I'm currently being held captive? How about adding on some charges of obstruction of justice and conspiracy? Does any of this sound appropriate to you? No, I'm sure it doesn't. I'm sure you will find this fair and lawful in all respects, and that the defendant's rights were honored. How my defense team and I just don't understand that this is the Contrapublic and we do things a little differently down here. Well, sir, this is the United States, and by all accounts, you are a criminal involved in a much larger criminal enterprise. Will you ever be prosecuted? Probably not, but that's not going to stop me from fighting you. I am an innocent man, and I know I will never get a fair trial in Monroe County. I know the only hope I have is if some outside agency decides to shut this circus down. Until then, you just know that I am not afraid of you. You disgust me, and no matter what happens, I won't rest until I'm sure this will not happen to anyone else ever again. With all the contempt you deserve, Franklin Tyrone Tucker. Now, I read that to you because of what Tyrone Tucker asked in his Facebook 5 years later as he's heading back to jail potentially the next 24 hours. And it's that he's asking for the Justice Department's involvement. So do your part if you're out there, if you want to help. And go to Ty Tucker's Facebook page, rewind this tape, get that case number, and file a complaint with the Justice Department asking them to intercede. I don't know that will work, but maybe at some point they might get involved here in something as egregious as this. But remember, this is the things Judge Jones was doing. This is why Ty Tucker got so frustrated and ended up ultimately going at it alone. What he's talking about here is that witness is a witness that is an exculpatory witness for Ty Tucker, who was able to say and that he actually was present at the moment that the alleged witness tampering occurred with April Walker, where he allegedly threatened April Walker. He was present for that conversation and was able to testify that did not happen. Now, that charge was ultimately dismissed. Gee, I wonder why. Because once they figured out that this witness existed, what they did is he had pending charges. So he was facing prison time. So what they did, and what Ty Tucker was so upset about is they actually entered into a plea bargain and made it a part of his plea bargain that he could not return to the Monroe County. And if he did return, he would be carted off to prison, which is not legal. It's not legal that a judge can actually restrict you from knowing, can actually restrict and keep you from going and returning to a particular area. And that he throws him out of state, knowing, and this is the point, knowing that he is a witness, an exculpatory witness. He didn't do any type of, the judge did not figure out. What he should have done is said, hey, if he was doing this right, you can leave, but you've got to come back for this case. He knew, and that's what Ty Tucker's so upset about. So what the judge did is he said, get the hell out of Florida, disappear, and your legal troubles go away. And get as far away from Ty Tucker and his attorneys so they can't bring you in and you can't help out Ty Tucker. Essentially tampering with a witness that was exculpatory to Ty Tucker. Now, eventually, they dismissed that charge. Why do you think they dismissed that charge? Because once Ty Tucker points that out, that the judge, the prosecutor, and a public defender who's representing a cooperating witness conspire together to work out a plea bargain that gets this witness out of town and keeps him away from Ty Tucker's attorney, and then says, you can't come back to town. If you do, a warrant's getting issued for your arrest. That's the ultimate corruption. This is the judge who, again, we go back to that article. You go back to that article. This is the judge. This is the judge right here that Mr. Morgan holds in such high esteem. And we'll come back to it. Remember what he said. You have to look at all the factors. You just have to. It always felt like Judge Jones arrived at a true sense of justice. So a true sense of justice, Judge Morgan, is interfering in tampering with a witness. That's in this guy who is okay with these things, who thinks Judge Jones is a admirable, honorable guy. The same Judge Jones who had held Tyrone Tucker captive for 2 years, who did everything in his power to ignore the due process violations, the numerous due process violations that occurred in Ty Tucker's case, from prosecutorial misconduct to tampering with witnesses to withholding information to withholding. Remember, Todd O'Quinn was withheld from the defense team. He was withheld from the defense team. His testimony was never presented to the grand jury, and it was only discovered later on through the IA investigations, which when they were forced to turn over the statement of Todd O'Quinn. Remember, these are the same people that later on after this, Pitcher ends up giving a deposition. And in that deposition, Pitcher says and admits that he turned over to Colleen Dunn. He turned over the pass key to all the digital files, which would allow them to be altered. All of this was known to Judge Jones, and he still denied that motion. Now, I still think Tyrone Tucker should have gone and let his attorneys beat this case because I still think it was a winnable case. But because of that, because Judge Jones was such, was literally a third prosecutor in the room, he felt like he needed to do this on his own so he could try to say things that Judge Jones would try to keep out, and that he could say them under the auspice of saying, well, I'm a pro se litigant. But it's clear now, Judge Morgan has made his true colors known. It's very, very clear that Judge Morgan is not here to help Ty Tucker. And as Ty Tucker heads back down to prison, this is the scariest part. We're going to get into that part right now. All right, so this is a blog. You can, I will try to put a link to this blog in because it's hard to find, and it's the person who created it has stopped posting on it. And we're not going to go through and read every single one of these, but there is hundreds of deaths attributed over the years to the point, and I'm going to show you the case, to the point that even judges in the appeals court were noting the unusual amount of unaliving or suicide deaths in the Monroe County Detention Center. And we're going to go through, I'm just going to kind of go through here and scroll through and show you the amount. Larry Honshell, 1229, hanging. Charles Mosher, hanging. Clarence Sampson, hanging. Look, these are all in just, again, in 1998. We're going to go through years and years and years as it comes up. Ralph Edward Ogden, hanging. David Tessier, hanging. And in this case here, there's a lengthy opinion, and this is, we're going to read this excerpt right here. The opinion is very interesting. The judge noted that the unaliving rate at MCDC was excessive. It was also noted that one detention deputy, Kenneth Kerr, had been personally involved in 3 of the unalivings. Excerpts from his opinion are below. 6th, MCDC had an excessive number of suicides in a 2-year period. The average jail rate is 107 out of 100,000. MCDCs probably exceeds the average rate. I am in the process of getting inmate population numbers, which will allow me to calculate that MCDC's suicide rate. MCDC failed to correct, modify, or otherwise change serious suicidogenic conditions at their jail. Officer Kerr was personally involved in 3 of these. The sheriff in his motion in Lamine to exclude the unalivings provided minimal details about 4 of the 5, including 2 of those prior to Tessiers. Inmate Larry Honchell committed or unalived himself on December 29, 1997, after being incarcerated for less than a day. So, again, and I understand these are older, but the point is this continues and has continued over the years. We've got, and we're just going to scroll through 11/8/99, hanging, unknown custody accident, unknown 2001, 2003, 2004, 2005, unknown 2005, 2007, and this is the one that prompted this is what prompted this vlog. We have gastrointestinal hemorrhage, in custody anoxic encephalopathy, drowning. How do you drown in the custody of the at jail? Blunt head trauma, unknown. In custody by water bottle, asphyxia by water bottle. I mean, this is crazy to see this amount. In custody, unknown. Valero Pacheco. In custody, hanging. Leonardo Hernandez. How has this not been investigated over the years? And again, this goes on and on, all the way through up to 2015. And from what I understand, this is something that Tyrone Tucker fears greatly. He's been told. It's been made known to him that if he found his way back there, if they get him back there, he was always worried that if he got convicted and he was put back in custody, he's not coming back out. So I bring this up. I hope it doesn't happen, but I bring this up because I want it to be known if something happens, if we hear a headline in a week or 2 weeks that he offed himself, then we have to do our part out here to make sure it gets investigated, and not by Monroe County officials, and not by the sheriff's department down there, but by the Justice Department. But I hope that he's going to take the steps with his attorneys to get them involved in this and ensure that he's going to be kept safely, and ensure he's going to be kept in custody in a safe way. And make sure that he survives. Let's talk about the gag order. So give me a moment here. I want to, and I'm doing a series on it, and I will continue to do that series, but we're going to jump the gun here. We're going to go forward because I want to get into this gag order, because they're already, that's where this also, I think, begins, because this is also by de facto a gag order. No, he's not living in Florida, Cam. He's living in Oregon. So that's what he's waiting on to figure out. Are they going to give him a chance to surrender? Are they going to give him a surrender date? Or are they just going to come in guns a-blazing and take him into custody? We don't know. So, again, it's unclear what they're going to do in that regard. So let's go over here and let's get the gag order up. Share this tab instead. All right, so what we have here, let me get this better in focus here. All right, hopefully you guys can see that. Yes. All right, so what we have here is the gag order. This is the original gag order. So I want you guys to understand And we're going to understand a couple things about this gag order. Well, order on state of Florida's motion for protective order to prevent extrajudicial comment. This cause, having come before the court on February 6, 2020, upon the state of Florida's motion for protective order to prevent extrajudicial comments on the court, having considered said motion, the defendant, Franklin Tucker's response in opposition, the evidence presented, pertinent legal authority, argument of counsel, the court file, and being otherwise fully advised in the premise, hereby finds as follows. The defendant, along with his two co-defendants, has been charged with first-degree felony unaliving, as well as other serious crimes. The case has received considerable media coverage, both locally and nationally, and has been dubbed the Treehouse Unaliving. This case has attracted public interest, not only because of the charges and the surrounding factual circumstances, but also because of the suspension from the Florida Bar of Assistant State Attorney initially assigned to prosecute the case due to ethical problems in an unrelated case, and the termination of a captain with the Monroe County Sheriff's Office due to her use of racially charged language while working on the case. The state now moves this court to issue a protective order requiring all counsel and parties to exercise reasonable care to prevent investigators, employees, and other persons assisting in or associated with this case from making prohibited extrajudicial statements until this case has been tried to a verdict. Co-defendant Roy Wilson supports the state's motion, whereas co-defendants John Johnson and Franklin Tucker oppose the motion. The court finds that contrary to defendant Tucker's assertion, the state's motion has been brought in good faith and that there exists a factual basis for the state and co-defendant Wilson to be legitimately concerned about the ability to find ability to find a fair and impartial jury. Now, remember, when this was initially instituted, there was the consideration of the other defendants. But in this case, that doesn't exist any longer because Roy Wilson's already been tried. Johnson's already taken a plea. So their trials, their need to be for there to be silence on this isn't a concern any longer. Untainted by pretrial publicity to hear and decide this case in the 16th Judicial Circuit, a small circuit with a relatively small number of potential jurors. Ms. Lauren Janae, Franklin Tucker's significant other, has created, with the knowledge and approval of the defendant, a webpage and a YouTube channel titled Free Franklin Tucker. Both of these media platforms contain discovery materials provided to the defendant during the course of this case, including both photographs and videos of the co-defendants. Moreover, one of Franklin Tucker's attorneys has spoken to the press about this case. In a December 2019 news article, that attorney was quoted as saying, "The state's case is horrible. The attorney's concerns about missing videotapes, a planted jailhouse informant, and the lack of physical evidence also appeared in the article." So it's interesting here, right? Judge Jones is upset because the misconduct, things that are absolutely relevant to this case and things that should be commented on and that the public should be aware of, he's upset. He says, no, we want to kill it. We want to keep it from getting out. In defense of her public statements, Tucker's attorney argues that the public has a right to know about prosecutors who lie and hide evidence, which they absolutely do, cops who direct their subordinate staff like neo-Nazi white supremacists, the conduct of law enforcement officers, and what goes on in a criminal proceeding. Absolutely they do. Counsel is correct. The public does have a right to know. But the public's right to access information is not absolute. A defendant's right to a fair trial is one of the most fundamental of all freedoms and one which must be preserved at all costs. Moreover, when a defendant's right to a fair trial conflicts with the public's right of access, it is the right of access which must yield. Okay, understand this, and we hadn't gotten to this yet in the series, but this is how crazy his reasoning is. He's saying we need to make sure that a defendant's right to a fair trial is preserved here by preventing the press from hearing about the corruption that's led to him being prosecuted in the first place, which would, in essence, prove his innocence. What? How is his right to a fair trial in any way being hindered here by the press becoming aware of the corruption and corrupt activities of the state attorney's office, of the prosecutors, of the police, of prosecutors trying to illegally use a informant against him, of trying to set him up, of all these things that they've been doing. And we're going to say, oh, we need to stop this from happening. No, Judge Jones just didn't want that to get out because he was worried that suddenly there was going to be national interest in his case. And suddenly, it might lead to outside authorities looking in. It might lead to the exposure of this stuff. It might lead to Dennis Ward not getting elected again. It might lead to Judge Jones not getting re-elected. Well, it's kind of an election. It's a approval. It's public approval process. A trial judge has an affirmative duty to minimize the effects of pretrial publicity. Shepard v. Maxwell. A court must determine whether a restriction on extrajudicial statements is needed on a case-by-case basis. In making its determination, a court should consider the three-pronged test set forth in Miami Herald Publishing Company versus Lewis, which balances the right of an accused to a fair trial and the public's right of access. 7. With respect to the first prong of the Lewis test, the court finds that a protective order is necessary to prevent a serious and imminent threat to the administration of justice. The court rejects defendant Tucker's argument that there is no evidence to support such a finding. State's Exhibit 1, which was introduced into evidence during the hearing on this motion, consists of about 200 pages, which thoroughly document the concerted media campaign engaged on behalf of Franklin Tucker in order to sway public opinion in his favor. It is certainly a fair and reasonable conclusion to draw from that evidence that in the small Keys community, where the murder cases are relatively rare, that such a publicity campaign poses a serious threat to the administration of justice. Yet the publicity blitz, the show of force, Tyrone Tucker's mugshot being shown all over the community, Tyrone Tucker being paraded in front of cameras, Tyrone Tucker being held without bond, Tyrone Tucker being reported constantly in the paper regarding the evidence that he's an accused murderer. Yet when he speaks up and says, let me defend myself and try to balance out the coverage here and say, well, no, what the state's corrupt here, what the state's doing here is wrong. And he says, no, in order for the defendant to get a fair trial, we need to silence the defendant so that the only thing that stands in the public spectrum in this small community is that Tyrone Tucker's sitting in a jail cell right now, accused by the police whom that community is going to believe in. That's all that stands. This is the frustrating. This is why this was such a frustrating thing for Tyrone Tucker. They silenced him. And they got their way for 5 years. And now, you saw it. I pointed it out. I've shown you the footage. Judge Jones was nervous because he knew that if this thing goes south, if he gets acquitted, if the Justice Department comes in, if they start looking at what happened in his case, Judge Jones, because of this order, when we get done with this, you're going to understand why Judge Jones was so nervous. And if Judge Morgan does this, reinstates this, then Judge Morgan will be accountable at some point in his career. His career will be in jeopardy if he decides to put this back in place. And maybe that's why he decided it's easier to just lock up Tyrone Tucker on a $3.1 million bond over a urinalysis error after he spent 5 years and spent an entire trial where he wasn't even being substance abuse tested. Remember that fact. He spent 6 weeks without that, or I don't know, maybe it's 3 weeks, 4 weeks without that happening because they were in trial. And yet you're going to go bust him down. You're going to revoke his bond. You're going to set a $3.1 million bond on a man because of a failed urinalysis. Come on, Judge Morgan. What are you doing here? And I hope somebody with a big voice and a big footprint, much bigger than my little YouTube channel, gets wind of what's going on right now. It gets wind of this situation because the paperwork's going to get filed. But Ty Tucker, if you're listening to this, you've got to get your attorneys back involved in this. You've done a great job of bringing people. People know who you are. They know what your case is about. They're going to pay attention. But you've got to get people in there who can file things procedurally, who can protect the record, who can allow this thing to fight on. Because there is a fight beyond if they do somehow convict you. There is a fight. There is a beyond. The appeals court can do a lot, but you've got to have a record. You've got to protect the record. It's one of the most important things you can do in a trial. And you can't go in there and expect that citizens sitting on a jury who don't know about this case, who aren't aware of the facts we are, that they're going to be able to figure it out. Because they're still going to be sitting there thinking to themselves, well, you've been charged with something. Something must have happened. Even, as we see on YouTube, it's not the comment section. There are supporters in the comment section, and even some of those supporters think to themselves, well, maybe there is something here. Maybe something is here. Maybe there is, could it be this? Could it be that? That's going to happen in a jury room. I've been in a jury room. You've got to have an attorneys standing there explaining how reasonable doubt works, giving a proper cross-examination. So they're focused on listening to the cross-examination and not the distraction of a pro se defendant trying to figure out how to operate in a courtroom. So that they can object appropriately, so they can get their objections out. They can make a record when Mansfield does dirty shit that we know they're going to do. Anyways, let's continue reading this because it's very important to understand how this all works. With respect to the second prong of the Lewis test, the court can identify no viable alternatives to a protective order in order to ensure a fair trial. The court has already granted a severance as to each of the defendants. The court will also give appropriate instructions during the jury selection and allow for individual sequestered voir dire regarding pretrial publicity, but those measures do not obviate the need for a protective order. In terms of the third prong of the Lewis test, a protective order will be drawn as narrowly as possible to ensure a fair trial, but also to respect the public's right to know, as well as the First Amendment free speech rights of those impacted by the order. Wherefore, it is hereby ordered and adjudged. So pay attention to this part. That from the date of this order going forward, any discovery materials produced by the state or reciprocal discovery materials produced by any of the defendants to the state shall be closed, i.e. sealed, from public inspection or disclosure for a period of 90 days from the date of production. Okay, notice the first line of this is not worrying about statements of Ty Tucker. It's worrying about protecting the discovery materials that they knew were going to be coming because of the depositions that were going to be taken, because of the investigations that were coming forth. This was meant to protect the authorities in Monroe County from public exposure for their wrongdoings. Any discovery materials filed with the clerk shall be immediately sealed. Disclosure of any discovery materials received by the attorneys from the date of this order forward shall be limited to the attorneys, staff, investigators working on the case, and the defendants. They sealed the discovery so that it couldn't get posted out anymore, so that the public couldn't see the issues. They couldn't see the things like I found, where we found that Todd O'Quinn says he saw someone jump in a truck and go. So he says it so that they can't see that he says it wasn't Tyrone Tucker at the scene and that it was John Johnson, so that he can't see that the Reed technique was used in the 6 minutes. They want all of that sealed up. They don't want the pitcher interviews coming out or the depositions coming out. They don't want Phelps's depositions coming out. They want it all sealed. That during the 90-day period, either the state or one or more of the defendants may file a written motion requesting that certain materials or information remain sealed. The court, now this is the part where Judge Jones knows he's the leader here. He's the keeper of the conspiracy. The court will conduct a hearing on any such motion, review the materials in camera, and rule thereafter. So what this means is, let me break down what this section means. It's the most important thing to understand. This is why Tyrone Tucker said Judge Jones is heart and center, dead center at the heart of this conspiracy of silence and conspiracy to cover this up, because he is responsible for determining, he's the gatekeeper for determining what the public was going to see. and would see in this case. There are documents that were sealed all the way up until this trial began that couldn't be seen by the public, that are still sealed today, potentially, because the case hasn't been done yet. Because what he was allowed to do was seal these documents until the end of the case, at the request of the prosecutors, at the request of the other defendants. And they would get sealed. So essentially, stuff would get put into the, on discovery on the website. It wouldn't be allowed to be downloaded. It wouldn't be allowed to be picked up. 90-day cooling off period. That way, any news people, anyone in the news, anyone who's interested in the case isn't going to be in a position to get a hold of the material, and it's going to die out. And that's exactly what happened. So upon the expiration of the 90-day period, the clerk of court shall unseal any discovery materials that have been sealed in accordance with this order, provided that no motion to restrict release of said discovery materials has been filed. The parties may also release and disclose such materials if no motion to restrict release has been filed. Again, it's kind of crazy, isn't it, that the whole premise of this motion was Ty Tucker's statements, was his statements that have been set up, was his, it's all about his statements. It's all about how he's damaging his case because his attorneys are making statements. He's making statements. Yet the first three parts of this, the main thing that they deal with in this is how can we restrict discovery and information from getting out to the public. That's what they're focused on. They're not focused on Tyler. And that's why we're going to see what Judge Morgan's made of. But Judge Jones has no way to deny that he isn't aware of the depositions, of the evidence, of anything that he ended up sealing in this case, keeping from the public view. Because he had to review it in camera. What that means is he had to personally review it, and then he makes a ruling on it. So anything that got sealed, he knows what that is. He knows the things that are sealed. He knows the revelations that he sealed. Petty Phelps depositions. Pitcher's deposition for a while was sealed. Although it ended up coming out in subsequent motions and became available. The IA reports, the evidence that was tampered with, the videos that were tampered with and chopped up. He had control of all of it. The notebook that nobody got to see of Penny Phelps. And remember, Roy Wilson's trial wasn't aired live. So we never, so the parts about what happened for those 3-minute missing minutes of the tapes that has now come out because of Ty Tucker's most recent motions. So why is the state coming through? Because they know people are out there asking questions. And now they want to come and reinstate this. This is why Judge Jones was worried about it. This is why he said, I have some, I'm not really comfortable. Because he wasn't comfortable putting this back in. Because he knew Vinnie Politan, law and crime, people had taken an interest. People were looking, and he was worried that this was going to lead right back to him. That if the real questions get asked, if somebody actually comes in and looks at this case and sees it like I have, like others have, for the corruption that's occurred, the railroading of an innocent man, the framing of an innocent man by a police captain, by a detective, by two detectives, by a prosecutor who lost her law license, who's now been rehired to that same prosecution attorney, to that same district attorney's office. That when someone finally sees this for what it is, Judge Jones is going to be the one that's going to be in handcuffs sitting in the cell. And so will Judge Morgan at some point, if he decides. So he has a decision to make right now because he hasn't got involved in it. But what he's about to do right now, if he follows through and he locks Ty Tucker up, he's going to make himself complicit in this because at some point, the truth of this is going to come out. It's going to come out. Rest assured. Because we will keep talking about it. And there will be enough people that will see this for what it is. But this makes Judge Jones undeniably complicit as his awareness of everything, because he's the one that cut off the public from being able to see what was in those discovery files He's the one that's able to decide what the public sees and doesn't see. He's the one that was able to stop the press from looking at this case and seeing this case for what it is. That the procedure outlined here, we'll continue reading. That the procedure outlined here does not apply to discovering materials which have already produced, obviously, because it's already out. That all counsel for the state and the defense and their investigators and assistants strictly abide by the provisions of Florida Rule of Professional Conduct, quoted as follows. A. Prejudicial extrajudicial statements prohibited. A lawyer shall not make an extrajudicial statement that a reasonable person would expect to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding due to its creation of an imminent and substantial detrimental effect. B. Statements of third parties. A lawyer shall not counsel or assist another person to make such a statement. Counsel shall exercise reasonable care to prevent investigators, employees, or other persons assisting in or associated with a case from making extrajudicial statements that are prohibited under this rule. That the prohibition against making prejudicial pretrial comments which are intended for publication also applies to all the defendants as well as, and get this, guys, Ms. Lauren Janae. There is no constitutional impediment to a court prohibiting prosecutors, defense counsels, and other interested parties involved in the case before the court from making pretrial statements which are intended for publication. Florida Freedom Newspapers, Inc. versus McCrary. 520 South 2nd at 36. Now, actually, there he is, because she's not an interested party. She's not part of the defense team. She's his wife, or she wasn't even his wife, I don't think, at the time that this was came out. I think they were still in the process of getting married. But they absolutely did not have a right to that. And this was the thing that one of the things he was running afraid from. They gagged a third party, and there was no constitutional basis to do that. And then they went further with this. They actually went after her because the New York Times, or a New York publication out of New York, publicized a story, okay, and there was an interview about their relationship and how they met, and there were some statements made in there, and they actually went, okay, and they attempted to put Lauren Janae in jail by holding her in contempt of court, and they attempted to use those contempt proceedings to hold Ty Tucker in contempt, which would have landed him back in jail because him being in contempt of court would have been in violation of potentially his pretrial release conditions. He could have found his way back in jail with an increased bond. Now, what happened is at the very last minute, Judge Jones, knowing how unconstitutional this is, knowing how against the law this whole deal was with restricting Lauren Janae, he said he was concerned that if they proceeded with a contempt citation, it would potentially cause Lauren Janae to bring her own legal defense team in, and then she would get interjected in the case, and then she would have a voice in the case. So he felt it better to dismiss the motion that the state made asking for her to be held in contempt. So this, ladies and gentlemen, is the original gag order, okay? This, ladies and gentlemen, is a big concern. The other thing that didn't happen in this case, which is required under state v. Talley, is they did not, to my knowledge, in having reviewed, and again, we will eventually get to episode 2. I will produce that, and you will get to hear the hearing that occurred. It will be read by me. Not the greatest voice, but it will be read by me. It will be on your screen. You will get to read it and review it as I'm reading it with you and breaking it down. And you will find they did not do what they were supposed to do. When you are entering, listen, the imposition of a gag order is something that the courts have held is something that has to be done with great care because it is infringing upon, it is restricting the First Amendment rights, which are very, very important and very serious. They're restricting the First Amendment rights of a citizen. And especially when it's pretrial, it's an unconvicted citizen. It's somebody that you're saying they're not going to be able to talk. They're not going to be able to have a word. They're not going to be able to speak. And you are, limiting that person's speech. So it is something that courts take very serious. But one of the things that they're supposed to do, especially in this case, which he didn't do, because he was restricting information from getting to the press. And one of the key holdings that the Supreme Court, the United States Supreme Court, has held is the press's job is, key job in reporting on criminal cases is to act as an exposer. And if there's government corruption involved, gag orders aren't supposed to be imposed. And because one of the key functions of the press is to expose corruption. So if you have a case that's involving corrupt officials, corrupt prosecutors, then a judge shouldn't get in the way of that, especially if it's information that needs to come out to the public. In this case, Judge Jones didn't give a shit about that. He just went ahead and issued the gag order. And I don't believe he had a member of the press. They are required to notify the press and put out a release. And they are required to have at least one member of the press address the court and speak as to how they feel the gag order, what their opinion is on a gag order, and if they feel it would be in a way that would infringe the rights. Because if it does, they have a right to say something about it. Thank you, Dolores. I appreciate it. Thank you very much. Yes, you're correct. Again, that's why I say Karen Reed's case has great parallels. It is a case that has great parallels to this case, and that is why it dispels somewhat the myth, that the idea that you can't have lawyers involved in fighting corruption. In that case, there is a tremendous amount of corruption going on in that case. There's a tremendous amount. There's a judge in there who's very, very, very who was a friend of, I don't know what we're calling them, the alleged people that may have done the crime, and they were called in. It's completely crazy. So I just actually got a communication from Mr. Tucker. So I want to make sure it's very clear that he did not fail your analysis. Okay, he did not fail your analysis. He showed up. So he says he didn't fail your analysis. Morgan issued a warrant saying I missed one, but it's not true. He went. I was told I couldn't take the test. I told pretrial and told them I get there early the next day, but I felt sick and told them that. But I laid down. Now I woke up later but still went and was told I couldn't take it again. Something to do with the computers. Todd, my pretrial guy, asked me to have them call him, which I did. He confirmed I showed up and was told I couldn't test and was told what the problem was. So he allowed me to take the test again, but told me I must get there earlier to make sure, just in case there was another problem. So I did and tested, and that was the last I hear of it until now. Pretrial didn't even file the violation in court, so I didn't know it was coming, but I was completely in compliance. So what we're, I want to be clear here on this. This is again, what I've just been told is that Ty Tucker, okay, this is a procedural issue. Okay, this is an issue where Ty Tucker takes a test. He clearly couldn't have failed a test. Let's be clear on something. We're talking about a period of time that if he would have failed the test, right? If this test would have been failed, then he couldn't have passed the test. Like, he couldn't have passed the test the day before any more than he could have passed the test the day later, right? So there was an issue. He arrives. There was a computer issue. He calls his guy, and all Judge Morgan gets is the idea that says Ty Tucker missed a urinalysis. Missed it. But then he ends up taking it. But Judge Morgan doesn't even look into this, and then he issues this warrant for his arrest. Is what I'm being told right now. Right? Which is what I was hopeful was coming through. But he doesn't look into this. He just issues the warrant because he has showed his hand. Because this is what he was looking to do all along, was return Ty Tucker to that jail so that Ty Tucker looks bad, so that it absolutely makes Ty Tucker look like he is not an honest guy. He's bond revoked now. He's sitting in jail. And they're worried about a damn gag order. What do you think what do you think this is going to do to the local press when they find out that Ty Tucker's bond has been revoked? These assholes are sitting here worried about Ty Tucker saying I'm innocent on YouTube to 30 people on YouTube, and they're about to communicate to millions of people that Ty Tucker is going back to jail because he violated his bond. How do they pick a jury under those conditions when you do something like that? Because this judge doesn't take the time to figure out what's going on. But I don't think it's that. I think this judge had his finger on that trigger. He had his finger on that trigger, I believe, a while ago. And that's why he kept insinuating, Mr. Tucker, you sure you want to, you sure you don't want to conflict me out? I'm going to make sure. I want to be clear. And I had a bad feeling. But, now he's going to sit him in jail. He won't be able to talk. He won't be, but the point of the matter is this is all garbage. We know it's all garbage. We know it's all garbage. We all know it's garbage. This is crazy. This is absolutely crazy. But we have the ability to do something about this. We have the ability to talk. We have the ability to continue to talk. We have the ability to make our voices heard. And we have to do that. If they're going to put him in jail, if this is going to actually happen, and it seems like it is, it seems like the warrant apparently has already been issued. So tomorrow morning, it's all going to get filed with the court. This all happened early, basically after hours today. So they're going to lock him up. But why? For what reason? Over your analysis being missed, a clerical error. I mean, again, we know why, though, because this is Judge Jones' water boy. This is his water boy. This is the guy that's carrying the water pail for Judge Jones. This is the guy who owes Judge Jones because Judge Jones put him there, because Judge Jones got him his judgeship. This is how he plans to move up. That's the bottom line. That's what this is about. That's what this is. Judge Jones, this is Judge Jones. And again, I worried about it. But when you read that article and you see that this guy is paying respect to Judge Jones, he's making it clear that Judge Jones is his mentor. Judge Jones is the guy who he most respects, and one of the reasons why he wants to be a judge. And that's the guy who has been ahead of this, leading this conspiracy against Ty Tucker to keep him in jail using all. Well, see, Cam, they should, but if the judge issues the warrant, it doesn't matter. See, that's the point. That's the point you got to understand. Pretrial should be able to fix it. Pretrial should have been consulted on this. The fact that he went and issued this warrant without even looking into it tells you it isn't about finding out what actually happened. It's about finding the excuse to lock Ty Tucker up. That's what we all have to be very clear on in this. This is not about giving Ty Tucker due process. He's entitled to due process. He's entitled to a fair process. He's entitled to evidence that's not tampered with. You can't fight tampered with evidence. You can't fight against tampered witnesses. You can't fight the lies of a prosecutor and a grand jury. That's a violation of your due process. And the only remedy for that is the case gets dismissed. But they haven't done that. They won't do that. What they're doing instead is they are trampling all over his rights. They're ignoring process. They're ignoring procedure. And this gentleman has shown it. He showed his hand way early. And I guess he feels locked in because Ty's been on the record saying, I want Judge Morgan to be my judge. I'm okay with Judge Morgan. I find, but this is why. There is one option. There is the only option. Attorneys must re-enter this case. They need to go to work. They need to start taking over again. And they need to determine what options might exist to remove Judge Morgan from this case. If there is any, although there really isn't at this point because Ty waived all those. But at this point, it's not impossible. This guy's not impossible to defeat. Nothing's impossible to defeat. Not when you have the truth. Well, problem with that is, Cam, is Peter Tragos is a civil lawyer. He'll tell you that, even the lawyer, you know. I'm very familiar with his channel. I love his channel. I enjoy listening to him. Peter Tragos, though, is a civil lawyer. So he's not a very experienced criminal lawyer. He will tell you that himself. He would not want to be taking a capital case at this point. Listen, the thing is this is some bad stuff, guys. This is as bad as it gets. This is disturbing as it gets. Or his dad. Okay. I got you. His dad. Okay. His dad is the criminal lawyer. Okay. Gotcha. I thought you were talking about, listen, I think it would behoove him to have an outsider maybe come in. That would be great. Get an outsider in there. Get somebody from out of state. Get somebody from Miami to come in and tear them a new asshole, because they need to tear these podunk prosecutors up. They need to get somebody from outside the establishment who isn't afraid, who doesn't sit at their dinner table, who isn't worried about going to war with them again. He needs someone to come in, a mercenary to come in from out of town, who isn't going to be worried about whether or not he's got to try a case in front of these people again. And they're worried about one thing. That's kicking ass, taking names, and winning this case, because it is a very winnable case. It is not impossible to win, but you got to get attorneys who are not tied in with the bar down there. Now, if his attorneys can do it, if the two that he had before, Jerry and Kara, believe they can do it, and they can set aside any concerns they have, and they can take their gloves off, and they can go in there with a kick-ass and take names approach, then all right, let them have the reins back. But if not, fire their ass. This is not a case that's going to take that long to get caught up on. Okay? John Travis Johnson can be destroyed on cross-examination. You get that young thug lawyer in there, he'll tear that. He would tear John Johnson up, tear him up one way and down the other, destroy him. Again, all it takes is getting the motion to suppress in is one of the key things to unraveling John Johnson. Okay, that's one of the key things. Gotcha. But it's it's that's what's got to happen. And but that is what we need to have happen. You got to have you got to get an attorney in there that is going to be willing to fight and be willing to come in and be willing to understand Florida law, which is why I would say you want, like I said, you don't want someone who's from Key West, but you want someone who's from the state of Florida, who understands Florida laws, understands how it works, And they come in and, like I said, Miami, maybe go up to other end of the state, bring them in and let them come in and kick ass and take names. But they got to come in and be willing to just mow the grass with these people. Mow the grass with these people, because right now there's no way your ass can get handed to you in the current way this case is right now. Take it to trial and lay out John Travis Johnson. I mean, they have nothing else. They have no evidence. The only evidence they might possibly have, would be if they get Ty Tucker into that detention center and they put somebody in there with him and manufacture another story off of a snitch. But let me tell you, it won't make any sense, because, Ty Tucker has already defended himself once in court. It would make no sense that he would be admitting to this to anyone. So, but would I put it past him to try it? Absolutely, I wouldn't. I mean, I would very well could do that. It's but this has got, at some stage here, we've reached a point to where this has got to be put in the hands of an experienced attorney. If Ty Tucker goes to jail, you've got to put it in the hands of an attorney. If you're in that detention center, it will be near impossible for you to do the things you need to do with this case. You've got to get somebody in there. And again, maybe Jerome, maybe Kara, however you say her name. Maybe they're not the ones. Maybe they're too deep into it. But there is someone out there. There is an attorney out there that can do it. There will be. There guarantee you there is. And it doesn't have to be. There's enough people out here who have seen this now, who are aware of this, who can look into things and can watch the voluminous things. I mean, whatever attorney wants to get caught up to speed, they need to come out and watch the various different YouTube videos out here, where there's a wealth of evidence right now. I mean, there's so much evidence that you're innocent. This should be, a case that any good trial attorney should be chomping at the bit to take and win and get in there. Are we going to get it dismissed? No. I think we can, but should we try? Yes. But, this is a situation where eventually it's going to click. But it's important that when this goes back to trial, that it be very clear and be very understood to the jury that's seeing this case. Again, remember, there's a lot of pieces in this case right now. There's the missing videos. There's various different things that can be that can, that when this final presentation gets to the jury, that can be asked for in this case. And again, what you need is, you've got to make sure you have an attorney that's strong, aggressive, that's up on case law, and that's willing to come in, because one of the things judges don't want to do is get reversed. And that's the threat that you got to run in with them. You've got to show them the cases. You've got to show them what exists. You've got to make them fearful of you. You've got to make them know that you're willing to go fight them. And that's what will move the dial. But at the end of the day, even if you don't get an Osakalumi instruction, probably won't from this guy. If he's doing what I'm thinking, if he's the way I think he is right now, we're not getting that. You're not going to get anything out of him. He's going to deny it, and he's going to make sure he's going to say, this is the steps. He's going to give you the very minimal amount of time to do whatever you need to do, and then he's going to walk you through and consider it waived. That's why I see this guy going. That's what he's telegraphed. That's what he said, and he's made it very clear. I'm going to procedurally let you know what you need to do, and then it'll get waived. You bring an attorney in. Listen, you got to remember, Ty, any attorneys you had way back at the beginning or whatever, we're in a different place now. We have a lot more evidence out there. There's a lot more things. There's an entire trial that went down that attorney will be able to see, right? There's IA reports. There's missing evidence. There is a voluminous amount of information now that exists that if an attorney is good, they're gonna know what to do with it. They're gonna take it and they're gonna kick ass, because this is a case that can be won and will be won. Remember, there were attorneys involved in the civil case that had to defend against the defamation of character, who argued to a judge to get that dismissed because the judge in that case saw the evidence for what it was, saw how bad this was. So it is possible to get a judge to see that. And I understand that the dismissal didn't happen last year. But guess what? It shouldn't have been expected it would. I understand that they were denied by Jones. I understand that. But you shouldn't have expected they wouldn't be. Because the only person, Jones, if he's involved in a conspiracy, if he's the leader of the conspiracy, which he was, and he issues the gag order, okay, he's not going to find a way to dismiss the case. Because by dismissing the case, he's implicating himself. You have to understand that. When he dismisses the case, he implicates himself. Jones himself could not dismiss this case. He got out of the case. He handed it off to his water boy now. Okay? He handed it off to his water boy now, Mr. Morgan. And Morgan ain't going to dismiss this, because that means his daddy, so to speak, is going to go down. So you're not looking for a dismissal here. You got to beat him with 12 jurors in the box. You've got to send in the warriors at trial to make the arguments that's needed, to argue it to a jury appropriately, who aren't distracted by anything but looking at the evidence. And that will secure the record, that will preserve the record, that will allow us to go, if it has to a court of appeals, and that they won't get out of it. But if you go into court and you don't procedurally do things, and you go into court with this guy's gonna make sure that record is iron tight, clad shut. And then he's going to make sure that cell door is locked tight behind you. And the only thing you might have is a federal habeas corpus down the road, because they're going to close down all of the record. They're going to take the record. No, if Morgan is dirty, you're not screwed. You're not screwed if you get attorneys in there who will fight for you, because you got 12 jurors that got to screw you first. See, you're looking for a judge to let you out. It's 12 people in the box that let you out. It's 12 people with an attorney who can argue, and this is not hard to see. I saw it in the first day of your trial. People have saw it with you being a pro se defendant. You brought all the attention you need. Now you just got to get the professionals in to unlock that door, to take off that ankle monitor and let you be free. That's what you got to do. So you've got to bring in the attorneys. There's no other way to get this done at this point. If you're right, you're screwed if you go to court as a pro se attorney against this guy, because he's going to walk you down. He's already starting to do it. And what does the attorney do? The attorney has a lot of remedies that they can do. No, you can't admit that. Here's the thing, Ty. What needs to be admitted? There doesn't need to be anything admitted. This is the point. To beat this case, okay? Understand this fact. To beat this case, you don't really need to admit anything besides, first of all, procedurally, if it's admitted correctly and there's hearsay exceptions and rules, they can appeal that. The motion to suppress, they're legally allowed to get that in. Okay? They're legally allowed to get that in. That motion to suppress can come in under a hearsay, under the only thing that has to happen is you have to get the custodian of records to come in. The custodian of records is the clerk of court. An attorney will be able to get that motion to suppress in. That is not a complicated matter. that can come in under hearsay, under and once it comes in and you certify that, that can come in and be admitted to the court. It is a lawful document that involves obviously the John Travis Johnson through his attorney made a sworn statement to the court. Okay, so that will be able to go before the jury. He will be able to be impeached with that. And when he gets impeached with that, that's going to be supporting that. Not only that, but he's going to be able to be impeached with the fact they're going to be able to properly bring in and do it flawlessly so there's no distractions to be able to bring in the statements that need to come in. They're going to be able to bring in and get your statements, portions of your statement in to ensure that Mansfield and company can't go back and say that there's only one way you would have known how blood got on that knife. No, there's only one way. Yeah, you're right. It's not that you were there at the crime scene. It's that you were told this by Penny Phelps in the course of an interrogation. That's how you found that. That's how it happened, and they're going to be able to get that in. No, but actually, Ty, what you're failing to understand is I'm not saying they can appeal it. Listen, something like that, they could file an appeal and have it heard. If they were trying to keep something out that's obviously can come in, okay, because what's going to happen is your attorneys are going to file the subpoenas and they're going to do the groundwork to get that in beforehand, okay. They're going to be able to have that already arranged. They're going to have that in their witness list. There's not going to be a way the state can keep it out. The state only kept it out because you weren't sure on how to do everything procedurally correct. Your subpoenas ran out, and Judge Jones was able to get that around you. Well, the thing is it can come in. Well, we'll see. The statement in its entirety can't come in because it was tampered with. But here's the thing, Ty, you have to understand, if they're going to say it was tampered with by a police officer or in their possession. Therefore, you benefit from the tampering, not them. That's where the Osakalumi case would come in to play here. That's where your attorney would be able to make that argument. On top of that, okay, the statement, you don't necessarily need the statement to come in its entirety, okay, because you don't really need that. But they would be able to bring it in for purposes of using it to show, again, to counteract the argument that's being made when they bring in the Paula testimony in regards to the knife. So, well, Lauren and the gag order, first of all, that should have, I'm not sure if it was ever attempted to be appealed, but that should have been taken up and appealed on an emergency basis. But probably Lauren should have filed, I don't know if she tried to, but she should have had her own counsel go in and challenge that gag order and appealed that. She had every right to do that under the case law that exists on gag orders. Anytime a gag order is issued under the gag orders is under the third party, she should have independently challenged that. That's why Jones, when the motions, remember when they went, well, I understand, Ty, but that's what they're going to try to do. They're going to try to bleed you dry, but that's what you got to do. You got, that's the opportunity they gave by involving Lauren, and then that ties it up and denies it. And listen, I understand. Money, it's expensive. I don't doubt that. I know that. I figured that. Okay. I know that. But I'm saying, Ty, that's why sometimes you got to figure out what to spend the money on. And I understand you didn't want to spend it on fighting the gag order. It's fine. You just decided to remain silent. No big deal. I understand it. But in this case, in this instance, getting attorneys in, that's what you've got to do. That's where the investment's got to be, even if it's just one. Well, I get 200,000. I can't imagine that. Well, that's crazy. And that's that they're price gouging. Okay. That's crazy. I mean, maybe for the entirety of the whole thing. I mean, I understand that's probably what the quotes are, but shop it around. Shop it around. Well, I know that might have been what they wanted, but if you're just bringing them in for specifically just the trial portion, um, maybe they're not the right ones. That I agree. It's a lot of change, but that's why. But you got to find someone. I mean, even if it's listen, like you said, you don't need a great attorney to do this necessarily. You just need an attorney who's willing to try the case, willing to kick ass and take names. Listen, Ty, you have a case, okay? Like my dad would say, you have a case that is going to gain national publicity. If somebody wants to trade cash for being the guy that gets off Ty Tucker, who is being wrongfully accused, if you got to find the right attorney. If this attorney is looking to make money on this case, they're on a one-time basis, boy, they're looking at this the wrong way. You got to shop it around, and you got to find the guy who says, listen, I'm willing to come in to make a name for myself. I'm not worried about getting paid. I'm not willing to get paid 10 times the money and make it all out just because of the perception that these people have money. So I'm going to try to gouge them out. But there is a lawyer out there that would take this case. Hell, remember, that one fella said he would come in and try it. Like he said, he'd try it for expenses. And what was it? Uncivil lawyer. Look, that's all you need. You just need somebody in there who can help to file the motions and understand procedurally how to get these things in and make an argument to the jury and not get caught up in the emotions like you ended up doing in the closing arguments when Mansfield baited you. You want somebody to go in there who's emotionally involved to the extent that they want to win this case because they know they got a case here where an innocent man is about to get railroaded in. But at the same point, they can come in and make a cogent, good argument, strong argument to the jury, argue this case the way it needs to be argued. Because the reality of the situation is, I did notice that. Yes, I did. I did notice the 1 to 2 months. I did. That was the weirdest thing to me. I thought, are we missing something? What I think that was, Ty, is I think that was because Mansfield and Company, I think they actually, I believe that they maybe had that motion sitting on the desk. Because I don't know if you caught it in the last case when they were before the judge. Somebody off camera, I don't know if it was Dennis Ward or if it was Alvarez, who it was. It sounded like Alvarez's voice. It said something, do you want to handle the gag order right now? And Mansfield kind of waved it. And kind of waved it off. Oh, absolutely. Listen, I agree with you, Ty. I agree with you. This is all planned. They're going to run you down there. They're going to stop you from fighting. Like, this is all planned because then, like I said, motion to dismiss ain't happening. They're going to figure out a way, whatever, they're going to figure out how to deny it. It's, that's going to get a lot of stuff out. You should still file it and still fight it and raise every issue you can. But we know this guy ain't going to dismiss this case. It gets dismissed with 12 jurors in the box. Well, we're going to keep as much. Listen, if you end up in the detention center, man, we're going to keep as much attention on this case as possible. We're gonna do everything we can, and there will be others that will watch this stream. There will be others that will see this. There will be others that follow your Facebook. This is different. That is the one thing that's different than what happened when you were locked up from 17 to 19. That's one thing that's different than when you were last year. You got people that are aware of your case and care about your case and will continue to fight your case in a public forum. But you've also got to get the right people to fight this case in court. And figure it out, and just try to figure it out, and it's not going to be money is not going to necessarily be, the guy that's, the lawyer that's quoting you big fees isn't necessarily, that's the first fail. I can tell you this. Let me tell you this, Ty, my dad, and again, I haven't told his story. My dad never cared about a fee. He didn't. He made a lot of money when he was practicing, but he never cared about a fee. He when he closed his practice, he had close to $1 million in unpaid fees. He never ever would drop a case because it was one of his things. He couldn't do it when he had to help people. People said you could have charged 10 times what you were charging. For my dad, it wasn't that. It was about helping people, and it was about the idea that he said when you take a case that's in the public's forum, he knew the publicity from that was huge. Listen, I know that. I know they don't care, but that's why you've got to have the right people in there. That's why you've got to have the voices for you fighting, because look, they lied to the jury, but they wouldn't have got away with that if you had a lawyer in the courtroom. That lawyer would have been jumping up and down. That lawyer would have, they would have never got away with that, because what happened is they got things in that they shouldn't have got in that would have never come in if an attorney was sitting there. And an attorney would have stood up there and absolutely nipped it in the bud, because Mansfield went down the road. Remember, he went down that road in the first opening when he did his opening, and you kind of got drawn in because you were angry and kind of just went after Mansfield's points and kind of got caught up in that. Whereas your attorney, I know that, Ty. I know that. I know they've done it for 30 years, but see, I'm not. These people do this all the time. That's what's been fighting about. Look, you got to understand, right? I've witnessed this for all my time on this earth, as I witnessed my dad do the things he did, and the things and witness his career, and witness how they came after him, and witness the people he's helped. I've been around it. I've seen it. I've lived it. I know it, and I know you can win, Ty, because I watched probably the best attorney in the United States that no one will ever know outside of West Virginia and the tri-state area in D.C. Okay, I watched him try cases. I watched him beat the government. I watched him beat corruption. I watched him do these things, and I watched him help other attorneys. And I watched him also help pro se defendants defend themselves against these guys and against the corrupt bastards that pop up in this stuff. And again, I'm not saying everybody that gets charged with a crime is innocent, because they're not. But there are innocent people that get in a lot more than people understand, just like you know that, and I've talked about that. But the bottom line is, it can be fought. You got to find the right people. And if you got a guy, the first time you interview an attorney and all they want to talk about, they can't see the value in a case like this, and they're worried about money and they're overcharging you, then you know what? Move on. Because the best attorney is not always the highest paid attorney. I can assure you that. Okay? I can assure you of that. But we got to get the forces. We got to get the voices in the courtroom. We got to get the voices. We got the voices outside. We got the people lined up that are willing to do this. I know I can too, but not short attorneys will do it. Well, listen, the answer to the dirty judge, Ty, is the jury. It's communicating to the jury, a dirty judge, and eventually you will. The cure for a dirty judge is getting it on the record, making a record, protecting the record, because sometimes, if somehow this jury gets it wrong, I don't believe they will. I think you will win this case, but if they don't, you have a protected record, and eventually it will come out. Eventually, someone's going to pay attention. Okay, because in a case like this, you're factually innocent. You are innocent. I've reviewed the case 110%, and as a result, this case with a competent attorney, and I'm not saying this is the best attorney, a competent attorney, okay, who can get things in that need to come in, who can cross-examine John Travis Johnson. This case hinges on John Travis Johnson. There's nothing else. There is nothing else. The judge controls somewhat, but you've got to have somebody who's not afraid of a judge, right? That's a key. That's what you got. That's what you got to find, is somebody who says, I'm going in there to win this case. And I understand I'm going to get pushback from the judge. I understand the judge might not want to do things, but they've got to but they've got to be willing to go in and advocate for you. And yes, I see chat in there. The question you had, what was the breakdown? I believe it was 8-4, 8-4 for guilty. The state tried to say it was 12 or was 11-1, and but it's, yeah. I mean, Ty, 9-3. Sorry, I'm correct. It was 9-3 guilty, 9-3 guilty, and that's startling. That's startling because I felt it should have been reversed, but 9-3 guilty. But there were 3 people in that room that said, and if you guys are wondering, I'm talking to Ty as we're talking. So a lot of your responses, I'm responding to Ty here as we're talking back and forth. That was after the Allen charge. Then went 9-3 after the Allen charge. So I think it may have been 6-6 before the Allen charge, and then it ended up going 9-3. Everyone. So, that, like I said, but the thing is, like, we have to be clear on this, Ty. As I've said, it's, I know. Well, yeah, absolutely, because the jury, again, this is the thing. You're going to get jurors back there who are going to be asking the question just because you're simply sitting there, even though, again, this is why an attorney is necessary to remind them, because the thing that's got to be clear here is when you get an attorney in that courtroom, regardless of what the judge is doing, Ty, you got to understand this part and think of it like this. You're thinking of it because you're innocent. You want to be proven factually innocent. We want to hand it to them and kick their ass. And I understand that. Trust me, I'm right there with you, right? I'm right there with you. I want to see these guys get their ass kicked and hand it to them, like, so bad. Not as bad as you, because you're the one that having it happen to you. But I want it really bad, sitting on the sidelines watching this. But you've got to remember, when you get an attorney in there, the presumption of innocence, when you're reviewing this case under the fact that they have to presume you innocent, the DNA, the way they try to slip that in there and say it was inconclusive. Inconclusive means it breaks to you. John Travis Johnson, you can't trust him. You can't figure it out. You don't believe him. You're not sure about him. Doubt. Reasonable doubt. That's the part that an attorney comes in and makes the argument correctly. Yeah, well, Ty, I understand that. Listen, here's the thing, Ty. You know we're dealing with corrupt people. And listen, I hear you, man. I hear you, brother. I hear you loud and clear. That's what should happen. But when you have corruption and you have a corrupt judge, and now you add the corrupt judge's water boy carrying Jones's water for him, trying to finish the job, his hitman, his hatchet man, the young fresh face who's supposed to give the impression that this is somebody, a new fresh set of eyes, which we now know is not. We've now exposed him tonight that he's not. Okay. But you can't expect that. They're not going to do that. But who is going to do that? You know who's going to do that eventually? Who will eventually recognize that? It's the appeals court. But we don't want to get to an appeals court. It's the Supreme Court down the road. Now, there's also another means that this gets recognized. Because remember, when you get acquitted, if you let the attorney come in and do his job and acquit you, you can then sue the shit out of them for the due process violations at a later date. And potentially, maybe out of that process, when you get the ability to depose them and bring them in and go in, maybe you can also get the attention to finally get the Justice Department to do something. So, well, no, I know that, Ty. We're not, listen, we're not playing for an appeal. I understand that. But I'm saying that's where the things you're talking about matter. But what matters right now is getting the people who can talk to the 12 people in that box. Your people that set you free are 12 jurors, not the judge. It's never going to happen. You got, as hard as it is, you've got to let go of your anger, at least from the standpoint of saying, well, this didn't happen and that didn't happen. That's not, when you bring an attorney in, the attorney ain't going to get this dismissed. That's not their job. I mean, it is their job, but I'm saying that's not going to be a realistic outlook at this particular moment. The realistic outlook at this particular moment for Ty Tucker is get this case to a jury, try this case in front of a jury again, and get 12 jurors to send you home. No, I got you. I know, right. But I'm just saying, that's what the focus has to be. And like I said, you could do a great job talking to the jury because you could stand there and say, I'm innocent, and speak to them. But there's a couple problems. One of them is procedurally, because you're not an attorney and they're not allowing you to, and this guy ain't going to let you have an attorney in the courtroom. He's going to deny a hybrid defense. He's made it clear. He kind of telegraphed that. He's like, Mr. Tucker, all motions haven't been reviewed. I haven't reversed the prior judge. And given the fact that this guy thinks the prior judge is the greatest goddamn thing to the justice system to come since, whatever, I don't think he's going to change that. So what we got to do now is we got to focus on saying, get the attorneys involved here now that can come in and argue this case to the jury. And we're arguing to the jury, and we're making sure that the jury isn't distracted by because what happens is when you're in there, as great as it may seem in practice, in thought, but when you're in there, one of the things that's going on was you're distracting the jury. You're allowing, or at least allowing the prosecutors a way to distract them away from the weakness of their case by having you over there trying to navigate things, having to navigate the way to do things. And it allows the judge extra time to try to think, look at this guy. He's holding up court. He's doing this and doing that. And instead of being able to come in and say, look, let's keep focused on what this is. Focus number one, we're here because the state says they have evidence beyond a reasonable doubt that you did what they said you did. Okay? Not sure if he's bad as yours, but we'll see. Hopefully he backs off there. Well, here's the thing though, Ty. I don't think he's worried about that. I mean, I think he's as bad as Jones because I think Jones and him are in cahoots. I think him and Jones are together in this. I think he was brought in for no other reason than because he's figuring, and what he was doing at the beginning was he was locking you in so that you couldn't have a way to get him off the case. That's what he was doing at the beginning of this. But he was saying, I want you to know I was part of the public defender's office, because he knew that would be the way you would come at him. So that when he starts coming at you and clamping you in and turning the screws on you, and you or maybe your attorneys come in and say, we want to bounce this guy off the case. He's going to say, sorry, you waived that, Ty. He might be, well now, yes, he is green compared to Jones, but that don't mean that he ain't dangerous. Okay, he's green compared to Jones, but that means he's also out to prove something. That means, to me, that makes him a little more dangerous than Jones, because what he's, from what I read in my research today, and I have no idea why I found this when I didn't find it in my original research. I just started finding all this stuff, but he's got to go before the public and get voted in again to be allowed to continue as a judge. That's coming up in 2024. Why do you think this guy's saying, I got to get this case is going to go to trial in 2024, Mr. Tucker? It's not going outside of 2024, because if he doesn't successfully get this done, he very well might not be a judge after 2024. Well, he might be easier to scare, potentially. But I think that the fact that he went and just issued this warrant, remember, what he's showing to you is he has the power at the end of the day to just lock you up, right? And not back off of it. He obviously nothing's been publicly made of this warrant yet, except for what we learned from you. And perhaps maybe he'll rethink this as he talks and he finds out, hey, wait a minute. But like I said, if you end up locked up, if this does play out and tomorrow you're turning yourself in, well, we hope that. I mean, at this point, I would suggest that, again, I don't know if you still have time to file a motion to bounce his ass off the case, but you want to bounce his ass off the case because I'll tell you, this does not leave me with a good, warm, and fuzzy feeling. Because even if you don't end up in jail after this, if the Chief Justice somehow overrules him or he backs off this, then you still got to acknowledge the fact that it's, well, Ty, it's not over. If it's not over by a long shot, it just means you got to get, you've got to get attorneys involved, and we've got to keep the pressure on. And you've got to, obviously, I know, well, maybe it might be over if something happens to you in there, God forbid, but I'm going to stay positive on that note. I'm going to think that that's not going to happen. Well, we do, and we know not to trust them, and expectations. And now, like I said, it's time to start preparing and getting ready for war and lining it up and figuring out who that attorney is that could come in at an affordable amount to try this case and be there as counsel of record, because that's what's got to happen. And remember, price tag doesn't make him the best. You guys got to find somebody who is willing to come in and fight, who's willing to come in and understand the financial situation, whatever it is, and say, and be reasonable about it, and come in and do it. Oh, I know. Listen, I know. But at the same point, Ty, as long as they think people are watching, okay, as long as they think people are watching, and again, an attorney will help with that process if you end up getting locked up down there. As long as they think people are watching, they're less apt to do something. I know, I saw, yep, and we were profiling that earlier tonight. I was running down the names. I know there's a lot of people that have gotten killed at the Monroe County Detention Center. I know it. I know there is. I know there's a lot, and I know it's a scary situation. How you doing, Sarah? Thank you for stopping in. So chat here says, I don't like the judge. It says, Dolores asks, why does the court record show that Tucker failed his urinalysis? If he didn't actually fail, it wouldn't it be easy to prove? No, it doesn't show. So I want to clarify something from everybody here on this statement. The court record does not show he failed. He did not fail a urinalysis. He did not fail a urinalysis. Okay. And unless there's something else on the record I'm unaware of, I don't believe, it's, but he did not fail a urinalysis. What he did is when he showed up later in the day, all right, he showed up later in the day. When he showed up, they said they were having computer problems and that they weren't going to be able to do his test at that time. He called his pretrial detention person. They got on the phone. They talked with the center. He said, no problem. We understand what's going on. Come back tomorrow, but show up earlier just to make sure that this issue doesn't come up again. So he shows up and next day takes his urinalysis and passes it. Doesn't think anything of it. And then he gets a call today from his pretrial release guy that says, hey, we got a problem. The judge just signed a warrant for your arrest, and you're going to have to come back down here and report because you're going back to jail, and it's going to be a $3.1 million bond. So this issue is not about any failing of your analysis. I'm going in to look and see unless something's come up that is different than but that's based on what Ty Tucker was told by his pretrial guy. That he was not told he failed anything. He was told it was it's absolutely outrageous. It is absolutely outrageous. It's very, very upsetting because again, and then as I laid out for those of you that have not been in the stream yet, or were not earlier. I was showing, yeah, no, nothing's in there. So there's been nothing on the docket yet or anything put in there. So, and I'll show this again for those of you who didn't see this earlier. So hold on here. Let me make sure. I want to make sure. I'm going to go back over here to. I've got to put up a layer. I don't want to show this man's family. I don't believe in doing that. They got nothing to do with none of this. Anyway, so it says basically what I was showing here is I found this today. I didn't expect it. This is from back in November 8th, 2021, when this judge in Ty Tucker's case was brought to the bench. And it says here, on October 27th, Monroe County's bench gained its newest judge and was sworn in, Jimmy Morgan, that's the judge in the case, and he was sworn in by Judge Mark H. Jones. Now, who is Mark Jones? Mark Jones is the previous judge in this case. He's the guy who was leading the conspiracy against Ty Tucker, who was essentially the one that's responsible for all of this. And he essentially recused himself and from the case. He has now, essentially revoked Ty Tucker's bond. So a graduate, but he goes on to say, and I can take this down because I did not want to show pictures of the family judge. When I graduated from law, he says here, hold on. Maybe I missed it. Make sure. He says, and it was a dream of mine. Or he says, okay, it was in Key West that Morgan had the opportunity to practice in front of Jones, who served as chief judge at the time. Being a judge has always been a dream of mine, and Judge Jones used to always say, each and every case rises and falls on its own merits. It's not one size fits all. Each case has its own factual scenario and different people. You have to look at all the factors. You just have to. It always felt like Judge Jones arrived at a true sense of justice. And then earlier above, Judge Jones goes on to say that he basically had, certified that Judge that Judge what's his name, Morgan. Well, hold on, I'll read it to you here. Give me a moment. I just got to put this back up. Like I said, I just don't want to show his family. So here it is. I always identified him as an outstanding person, not just as a lawyer, but as a human being in terms of his character, his commitment to duty, and his diligence, said Jones. So Jones endorsed him for this. He swore him in. He was the head judge. On top of that, Judge Morgan goes on to gush about how great the judges are in the area, how great the lawyers are, and what an honor it is to be part of this justice. Basically demonstrating that he ain't here to shake anything up. He certainly ain't here to help Tyrone Tucker, who represents one of the greatest cases of all time, or hold on here. Hold on, guys. I'm trying to get something here. I don't know why it's doing this. Give me 1 second, guys. I'm trying to. anyways, I apologize. Yeah. So, anyways, this is the but this is the article that I was sharing earlier, which ties in. And on top of that, I also found out that Judge Morgan is up for essentially judges. Once they get appointed to the bench, they have to every 2 years. If they get appointed midterm, within 2 years they have to have basically a public vote where they get a public vote of approval from the community, and then every 6 years they have to go through that. If they get voted down, then they will end up getting booted out of office, and then the governor would come in and appoint another judge, and process goes on. Within 2 years, they then have to have an approval. So the point is, this year he is up for he is up for he is up for I guess approval, so to speak. So that's significant because the fact that that's coming up this year, judge or not judge, prosecutor Ward is also up for election this year. So I don't think it's any coincidence that we've heard almost an obsessive amount of times that this judge has said this year we're going to be making sure that this year we're going to be is we're going to make sure he's tried by the end of this year, and that's what I think is a telling remark, because I think that to me telegraphs that this guy is here with a job to do, and he's here to take care of this case and get Ty Tucker tried, sealed, convicted, and delivered, and to get him and walk him through that process, waive his rights, and lock him up so that it can't be appealed, and this whole little problem goes away of theirs, and it makes sure his boy, Judge Jones, who earlier we just spent some time going through the gag order, which shows you why Judge Jones is the leader, the ringleader, the conspiracy leader in this, because he is the guy who was sealing all the documents. He created a caveat in that gag order where all everything got sealed, and he in camera had to review everything that all evidence before it got unsealed that the state or the defense attorneys requested be reviewed, and the state did that quite a bit. Anything that was unfavorable to them, they would simply request it be sealed. Judge Jones would review it and seal it. Therefore, when you look at him as who's covering things up, it lands right at his door. That's why he wouldn't reinstitute this gag order, because when all this press comes in, and he's got people like Vinnie Politan, he's got Court TV, he's got Law and Crime, he's got this overwhelming interest in the case, and he's got people on the internet looking at it, and he goes, oh man, we got to step back for a minute. Holy cow. And that's why he ends up recusing himself. And who does he send in? But the guy, his mentor, or the guy he mentored, the guy who says, I became a judge because of Judge Jones. Basically, as I said, Judge Jones' water boy, the guy who's going to carry the water and bring this thing to fruition, who's going to act as a judicial hitman on Ty Tucker, none other than James Morgan, who comes in. First thing he does is he tries to look like, hey, I want you to know I worked at the public defender's office. I was around this. I was around the people that were, I was going to switch, I was going to go to, he's going to go in and take care of business. So that's what's going on right now. That's what I believe is going on. And as a result, Judge Morgan ends up, playing Ty Tucker a little bit by saying, hey, let me tell you, there's a conflict, there's this, and Ty waives it, and he gets Ty to waive the speedy trial, and he walks him through, and this is what he's brought in to do. And he's going to say, Ty, I'm going to walk you through it. I'm going to tell you what you need to do. You need to do X, Y, and Z. You have this amount of time to do it. And then when you don't do it, it's waived. And it's waived, and it can't ever be considered on appeal because you waived it. And you waived your appeal rights. And you waived you waived your ability to challenge it. And that's what the that's what the that's what the situation is. Give me one moment, guys. I've got to step away for just a moment, okay? Give me one quick second.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast. I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains that last, and to believe in what you got, it was built to last, yeah. Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Gonna learn the consequence of being incompetent. Mental health is confidence, dreams and some modestness. I'm not here to save the day, that's for you to take away. I could play a million mind games, but instead I say something not illogical, something that is topical. Rub it on and watch it go, make yourself unstoppable. Dreams are irresponsible, but they're always possible. If you just believe, you could be so remarkable.
Thoughts in my head, a collage and they spread. I'll be great one day, going off of my meds. No, I'm not giving up, no, I'm not giving in. I will make it to the top, taking off in the wind. I gotta make it, I'm saving every day to taste it. I'm patient, but my mind, it can hardly take it. I'm chasing a dream that I've had for several ages. A vacant, modern kingdom for the taking.
Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast. I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past.
And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains that last, and to believe in what you got, it was built to last, yeah.
Now that I've been put through hell, never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Gonna learn the consequence of being incompetent. Mental health is confidence, dreams and some honestness. I'm not here to save the day, that's for you to take away. I could play a million mind games, but instead I say something not illogical, something that is topical. Rub it on and watch it go, make yourself unstoppable. Dreams are irresponsible, but they're always possible. If you just believe, you could be so remarkable.
Thoughts in my head, a collage and they spread. I'll be great one day, going off of my meds. No, I'm not giving up, no, I'm not giving in. I will make it to the top, taking off in the wind. I gotta make it, I'm saving every day to taste it. I'm patient, but my mind, it can hardly take it. I'm chasing a dream that I've had for several ages. A vacant, modern kingdom for the taking.
Now that I've been put through hell.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast. I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past.
And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains at last, and to believe in what you got, it was built to last, yeah.
Now that I've been put through hell.
All right, guys. Sorry about the brief delay there. Get caught up here. What's going on here? All right. So a couple things here. I apologize, like I said, for the delay here. Here we go. Okay, so Ty is in there. I put a link to the DOJ complaint online and my complaint number for if they can get even 100 complaints, they might actually do something. Absolutely. Absolutely, Ty. And I would, let's see here. Won't be the last if I want people have trouble. Let's see what we got here. Understanding how bad this is, trying to argue your innocence against the mob. Yep, I can't imagine. What do you... Okay. But yeah, Ty, look, one thing everybody can do is go to the complaint and file a complaint and link it to Ty's complaint. I'm doing the same. That's the minimum we can do. And if we can get a whole bunch of people to do it, we need to get as many people as we can. So that would be great. We've got to try to get, again, Ty, have you been able to reach out to like Vinny Politan or Court TV? Do you still have any connections from back when you were trying the case that you can try to get them to cover this or cover any of this or cover the fact that they're revoking your bond or potentially going to revoke your bond? Because to me, I think that if Vinny's willing, I mean, he seemed to be someone who recognized that there were problems with this case. I think it would be fantastic to to have him involved. But anyways, you know. Oh, so Court TV did respond quick. Excellent. That's awesome. God, that's awesome. Because they know. I really feel. I mean, watching, and Vinny's a prosecutor, so to have him talking about this, is tremendous. That is something that I think is would be a tremendous help. But the most important thing, Ty, that you can do right now, again, is find. So, again, it doesn't have to be the most expensive attorney. I know that they're going to probably expect to be paid a lot because of the press that you've received and who your wife is. But the price you quoted that Kara and Jerome were asking for is outrageous. That's nuts. If they can't see the benefit of being involved in a national case with national headlines, that's an insane amount of money. That's a lot of money. But man, I mean, not to mention that, hopefully maybe they would take a payment plan. I mean, there's, I mean, to me, they've got to see that if, that there's benefits down the road, that if they beat this case in the criminal court, they could, I don't know if they do civil stuff, but they could be involved in the civil action that would come and follow this. I mean, there's got to be some ways here to, well, no, I know you can't, but I'm just saying that they will. That's what you've got to tell these people is saying, hey, listen, they're going to expect it. That's the problem. They're going to expect it. They're going to expect that she's going to come, and because of the press, because of the way it's been positioned in the press, that's kind of a detriment to you, because the issue at hand is, I mean, and here's the thing, Ty, you got to understand this, you would not be entitled to any type of appointed counsel or anything because maybe it's not the case in Florida, but I think they're going to count the fact, as long as you're married, that's going to preclude you from having appointed counsel. So she's going to be a factor in there just because, but that's, there's got to be a way to get an attorney in. And like I said, I mean, to me, I mean, you take away the available money, there's monetary value in the sense that you finding an attorney somewhere who would say, man, I'll get involved just because, I'll get involved just because of the publicity, the value of that publicity for them. If they beat this case, like for instance, look at what happened when Jose Baez won the, what's her name? Casey Anthony case, right? I don't think Jose Baez got $200,000 for that case. I can assure you he didn't. Okay. I remember I read his book. He didn't get anywhere near that, but I can tell you he's gotten millions of dollars since that case because he beat that case. And that was a Florida case. Now, Jose Baez would probably charge a ridiculous amount of money. But Jose Baez, I mean, have you ever considered reaching out to him? I mean, he's involved, I know, in that Microsoft case. But I mean, he was a guy that was that was fighting, hell, he was a shopping center lawyer. In other words, his law practice was in a shopping center prior to Case Anthony. I mean, and he loves a good fight. And if somehow he was able to get involved in the case, now, like I said, obviously he may want to, charge an arm and a leg, but I mean, because he's somebody who's now in demand and he wants to, but to me, you find a case like this, it's like, man, what about the other thing too, Ty? Has the Innocence Project reached out to you at all? I know they kind of deal with things after the fact, but sometimes the Innocence Project will get involved with cases even before a conviction's occurred. and help you out, because technically speaking, I mean, you know, you're an innocent man that's being accused of a crime and you've already been tried once. I feel like that would be a place that you could find a hungry attorney that could get in there. Well, look, I guarantee you, Jose Baez would absolutely be somebody that if you could get him involved in this case, he would kill. There's no guarantees in life, but I really firmly believe, having watched what he's done. Listen, I watched what he did in Casey Anthony's case. He went up and he got Aaron Hernandez off. Okay. Remember, right before Aaron Hernandez committed or unalived himself in his jail cell, he brought in Jose Baez, and they tried. There was another case that he was being tried for. It was he got convicted of the killing the guy on Father's Day, but then he also had a drive-by shooting case, and he absolutely killed it up there. And he might have even got, that he was going to be working on the appeal, which is why he was shocked when he took his own life. But I mean, I'm telling you that he can, he's excellent. I mean, again, that's the type of guy you need. And that's the type of situation where it's like, you got to just sit down with him and get into the honesty of the situation. But a guy like him, I read his book, and I think that he would be somebody that he would be moved by the potential innocent individual that he sees sitting in front of him. Who's Bob, Sarah? Who's that? Who's? Let me tell you, they're not going to eat him up. They're not going to eat him up. The Bubbas, they're not going to eat him up. I can assure you of that. And he's a Florida lawyer, so he knows the Florida law. He knows how it works. They will not eat up Jose Baez. I don't know about Bob. I don't know who this Bob guy is. Bob Mata. Okay. Bob Mata. Okay. Okay. But I can assure you, they're not going to eat up Jose. Now, I don't know about Bob Mata. Let me look up who he is here. Looks like he's top 100 national trial lawyers. Well, it looks like there's a couple. There's a father and a son, and they're out of Chicago, Illinois. Yeah, I mean, the thing is, I would say though, bringing in a guy that's not in state has its own dangers, and that might be one reason why there would be an appearance of getting eaten up because they're not familiar with it. Well, they got to understand though, again, with him being out of state, he probably got his ass handed to him because it was the bond hearing, and he probably didn't, to be honest with you, he probably didn't prepare as well as, didn't, wasn't as necessarily prepared with things. I mean, a lot of times when you bring a guy that's from out of state, it's a tough situation sometimes. I mean, that's no excuse, especially if you paid the guy a lot of money. But that's why I'm saying you want to get somebody who is not necessarily out of state, but is out of the area of Key West, so they're not worried about having to practice with these people again. Well, I was going to say, yeah, I mean, and the laws are different. I mean, it's a lot. There's a lot of factors, That's why I would say, don't judge that. Don't judge that experience. I'm telling you, you get somebody that's out of the area that's like, say, I mean, hell, you might even consider looking around at I know the attorney that, well, yeah, but now, Ty, here's the thing you're going to have to understand. when an attorney comes in and they get involved, number one, I don't know that they can move the trial up because I saw that 1 to 2 months. That was something that they kept saying even that day when they were talking. When they set it up, they were like, "Well, it's going to be 1 to 2 months, or it's going to be, we'd like to get a trial date maybe in June or July." It's not. That's not going. I don't think it's going to work based on the timing and the length of the trial. So I don't think that's necessary concern. I think the earliest you might have a trial happen is August, and that's if, as he said, if some of these motions collapse and fall on their own. But you've got to get, but when your attorney enters, they will be allowed, they will be given time to get prepared and up to speed. That is something that will happen. And I'm not saying they're going to give them into 20, outside of this year, but if somebody got involved right now today, case like this, they could get up to speed by September with no problem, in my opinion. I mean, I don't, obviously I'm speaking for somebody who might have other trials and other cases involved. But again, once an attorney's involved, that becomes not necessarily judge wouldn't allow. Wouldn't allow what? You mean as far as other attorneys to get involved in the case? Is that what you're saying? Well, because you got to remember, again, when the attorney comes in and gets involved in the case, they're going to have. I mean, they're going to have to give him or give them some time to get prepared, and it's also going to have to work around their schedules. So you got to remember that too. Nothing's ironclad. So your attorney comes in and says, "Well, I have a trial date this date or that date." Well, nothing. Listen, now nothing's ironclad. Nothing is no matter what. And at that time too, I believe if you would have had attorneys there by that time, but I think he set that in August, but there's always a reason it could get delayed. There's always a chance it could get delayed. There's always look, again, Ty, one of the things you're missing here is attorneys find ways. A good attorney will find ways to delay a case or get a continuance if they need to. And if you have an attorney that's telling you differently, you probably have the wrong attorney. And because I can tell you right now, my dad, there was never a case that was set in stone. Well, no, I know you did, but I'm saying it was set. That's what the judge is saying, because the judge wants to encourage that this thing's got to go to trial. But if they create an issue that has to be resolved, then that set in stone by the 8th, again, there's ways around it, because at that point, they could go to the head judge and get things done if they needed to. It's but it's something that is nothing's ever set in stone. But at the same point too, I believe if your attorneys would have shown up at that trial that we had in January, I think that, again, I think there's a strong possibility you're getting a not guilty verdict in that instance, because your attorneys would have been able to really hone in. I mean, they had no evidence in that case. All they had was John Travis Johnson, and then they finagled this stuff with Paula. But the bottom line is they would have been able to, again, remember, you would have had, if your attorneys were involved, they would have been able to have someone at the hospital monitoring what's going on. You were trying to operate as a one-man show. So the state got away with a lot of things. Well, no, I know what the order said. I think I saw it in the record. It said no continuances. No, but again, like I said, nothing's ever ironclad. Judges can say whatever they want, but they don't always get what they want. That's And again, I say this with the utmost confidence because I witnessed it firsthand. Like my dad was the king of continuances, and he trained others to do it. And I watched and witnessed it. I watched him help other lawyers. I watched him create the issues. I watched him create issues that nobody ever. And when we were at the funeral, a lot of it's up right on my mind because we were at the funeral and hearing people talk and stand up and speak about him. And these were lawyers who are great lawyers in the community that were around, who he worked with, who he helped. And they were telling story after story of the incredible things he's done. So I know it can be done. That's why I know it can be done. I know the impossible can be done. Right. Well, but that's also why, Ty, he prejudiced the jury pool. But how many of your jury pool do you think actually read what Judge Jones put in that? That's the real question there. So the point of getting when you take the jury pool, right, and he gets in there, the point of it is that your attorney's going to get to go in and start to question and do what they call voir dire, which you're familiar with because you went through it, and they're going to get to question them and figure out what influence they had or didn't have, over that the population. Well, I understand that. But what I'm saying is I don't think a lot of those people were necessarily reading that order. They might have seen stuff in the paper, but that's where your attorney's got to come in and say, okay, what have you seen? What have you heard? But even if they heard that, in the motion to dismiss, by the time they got done the trial, if these are law-abiding citizens, and remember, I've been in a jury room, I sat on a jury, okay, and the jury I sat on was a well-publicized case in the community that I was in. It was involving a principal who got stabbed by her brother in a huge case. And we were back there. So there was people that had heard about the case, knew about the case. They were questioned. They were vetted. We, got us out. So I know that jurors do take their job seriously. But at the same day, at the end of the day, they sometimes will presuppose and add things in that they really shouldn't. But the point is what I'm trying to say is I don't think the impact was as great as what you thought it was. Okay. And your attorneys coming in, and when this jury would have been sitting here seeing this case and looking at it, and there would have been the ability to get in some of the witnesses that you wanted to get in, but you weren't able to get in because Jones was able to pull his bullshit and keep them out. And you were able to put forth the case, maybe even testify like you did. I mean, listen, anybody, in my opinion, that would question your innocence, who watched that trial and saw you get on the witness stand unplanned and be able to handle yourself the way you did, that seals the deal. I mean, again, at that point, I hadn't even looked at the stuff. But when I saw that, I was like, I hadn't looked at it. I looked at some stuff, but not the voluminous amount of stuff I've looked at now since then. But that alone is tremendous for you to be able to get up on the stand and handle Mansfield like you did. Well, the bar dropped the complaint probably against her because the case didn't get dismissed. See, that's the impact. The case didn't get dismissed. The judge didn't make the finding. So you got to understand, again, well, I know she's rehired now, but the point is, these things we should expect, these things we should expect when we're dealing with corruption, right? We expect the judge to do what he did and protect Colleen Dunn. Because remember, she's a co-conspirator of his. Dennis Ward is a co-conspirator of his. These police officers are co-conspirators. They're protecting what they do down here. So the only place you're going to get is you're going to get 12 jurors. The fact that you were able to convince 3 to stick with it and refuse to deliver a verdict and say, hey, I think he's not guilty. I mean, that's tremendous. That speaks volumes, because I guarantee you, if you had an attorney in there who was able to articulate things for the jury a little bit better, and they were able to cross-examine John Travis Johnson, utilizing the motion to suppress, if they were able to keep some of the bullshit out and go in and make sure that things were done ethically and correctly, and be there to argue and keep their cool and put the closing argument out that highlights the fact that the burden is on the state to prove this case, that the jury is required to presume you innocent, and explain what that means in relationship to the DNA, explain what that means in relationship to all these different aspects that were going on. That jury would have come back with a not guilty verdict. Well, and again, now you got to understand, I know that's what he said in that motion, but see, this is why, Ty, this is why you're so, and again, I understand why you are. I understand 100% why you are, but you're so emotionally involved in this thing that when you look at things like this, it hits you harder than it really hits when you consider the source of who that is, and that Judge Jones is saying, okay, this is the finding I made. He says that. We expect that, but that's okay. He's the guy carrying the water for them, right? The problem is you really couldn't address any of that until you go get convicted, which we don't want to have happen. And now an appeals court can come in and look at it. Right. I understand that. I understand you had 3 officers admit that. And I understand that. And but the problem is that you were going to ask a complicit co-conspirator to acknowledge that and dismiss the case. It was never going to happen. It just wasn't going to happen, because he would have to then say, by doing that, remember, when you look back at the history of this case, he's all over it. So there's no way in the world that he can dismiss this case and say, yeah, all that's true. So he had to do what he was doing. So that's the problem. That's the problem, is that you're not going to get him. You were never going to win. Well, here's the problem, Ty. I'll tell you what. The problem is, at the end of the day right now, you're still accused of a crime that hasn't been tried. What will move that? What will move that is either getting a judge, which you're not going to get because that judge is part of who they're going to come after, either getting a judge to dismiss the case and make a ruling that says I'm referring this to the Justice Department for investigation, or B, a jury acquits you. A jury acquits you, and then you have the attention now of the press and people who look in and say, how did this guy get acquitted? And then you file a civil suit. And then you get a judge there to acknowledge all these problems. And hopefully in that process, you get a referral to the Justice Department, who's already been referred the case, says, okay, we got to look into this now, because the jury just acquitted this guy. What happened here? Why did they acquit him? Now people got to actually answer these questions. Jones got to answer these questions. This guy is going to have to answer questions. And yes, Ty, I agree with you 110%. 110%. You got the cameras. You did. That was exactly what you wanted to accomplish. Now that you have the cameras on the courtroom, and again, I understand financially, there's concerns. But now that you have the cameras on the courtroom, it's time to send the lawyers in to finish the job, because they will watch this time. Everyone will watch this time. Everyone will be ready this time. Everyone will be ready to celebrate the acquittal that we know is going to come. But you've got the attention on everybody. Now you should be getting a discounted legal fee because you got the national media back on this thing. And whoever steps in that box and gets the acquittal has just wrote themselves a gold mine of cases in the future. They will make way more money off of the cases they will get. Oh no, I know, Ty. But I'm just throwing it out to you. They will make way more money off that. So that's why you've got to go out and sell that. And you're a good salesman, I could tell, because you did a good job in front of the jury. We got to see those skills. We got to see you up there talking. Now it's time to sell the idea here. You win this case, man. Like it unlocks it. You know, case gets won. You know damn well Netflix is dusting off the film and that thing is coming out. That lawyer's going to be in it. You know, best thing for you to do right now, honestly, Ty, is to reach out to those Netflix people and say, listen, I want you to come and film me behind the scenes or film behind the scenes, whether it's at the jail or not. But you need to get them back involved. They're your ticket to never die, right? Because Netflix needs to come in and be videotaping the entire time behind the scenes, getting hours of videotape, which they can do. Remember, there was well, maybe you don't remember, but there was a case in North Carolina. Michael Peterson he's a book writer. He was a famous author, and his wife fell down the staircase. And they were able to come in and videotape the entire trial. And then when he got a new trial, they came in. They were videotaping at the jail and behind the scenes, but they were videotaping. You know, they were able to come in and document the whole process. But you do that and sell that to the attorney that takes your case. You know, that's the no problem, Ty. That's the benefit there. You know, is you would be able to sell them on the idea that, hey, I got all this coverage. You know, you're going to be featured. Like, this is your moment. This is your breakout moment. This is your Johnny Cochran moment. You come in, you get me the acquittal. You come in and you get me off. Man, you're getting all the credit for it. I mean, that's it. And you know, if you need someone to sell them on it, let me know. I'll sell them on it. I'll call them up and say, listen, you need to understand, if you're focused on money right now, if you're focused on getting paid, it's like the old adage where, well, you probably heard about it where believe it was Magic Johnson had the opportunity to get stock in Nike, or I think it was $100,000, and he chose to take $100,000. If he'd have taken the stock shares of Nike, he'd be a billionaire right now just off of what he got. So, you know, again, the idea is don't take the money. Cash devalues over time, but the ability to build the reputation, the ability to gain the media attention and go in and grab it, that's the real benefit here. But yeah. So Ty, when will you? Have you been told? When you're going to know something, as far as self-reporting, or if you're going to have to turn yourself into authorities in Oregon, or what I mean, if you can provide them with a plane ticket that's booked and ready to go, I would imagine they would be open and amenable to allowing you to, maybe that would help with allowing you to fly down there, show up in court, and make it clear that you're not a flight risk. Well, yeah, but have you considered, Ty, is he going to allow cameras in the courtroom, or is that going to be his next strike where he's going to try to throw the cameras out of the courtroom? Um, you know, I mean, to me, I think as long as what you might consider doing at this point is when you contact the judge, buy a plane ticket with it, an open-ended one-way ticket, you know, let them know you have a ticket ready to go, that you're planning to be in Key West on this date to deal with whatever warrant or whatever situation you have, and contact his office, and put it in a press release, because what you want is you need to get ahead of this so that they cannot make it look in any way, shape, or form that this is because you're trying to flee, or this is just to do with you not want to show up, and have that plane ticket, release it to the press, send it out, and let them know I'm going to be in Key West on I don't know what's today, May 2nd. So I'm going to be in Key West on May 5th. And I'm showing up, and I'm going to be down there, and I'm going to deal with anything that's going on. So I'm making it clear there's no reason to come and pick me up. There's no reason to come and arrest me. There's no reason to spend taxpayer money on extraditing me. I'm coming into town, and I'm ready to fight. And if I got to go to prison, go to jail, I'm going to jail. But I'm going to be walking in, and you arrange Benny Politan and his Court TV or CNN, Jake Tapper. I know he was involved in a case out of Philadelphia where he helped a wrongfully accused man. You reach out to them and you say, listen, I'm going in I want it videotape when I go in. I want the condition that's going in. I'm going to go in. And the other thing I would do too, Ty, is, well, exactly. But, you just want it to be completely apparent. The other thing I would do right now is, if you have access, you need to get in contact. I don't know if you have a doctor right now, but the other thing you want to do right now is you want to also have a mental health exam done, if you can, before you go in. And the reason why you're doing that is you want to be able to have it on record that you're not suicidal, that you're ready to fight, that you're in a good mental state, and that you're fully prepared to go back to jail if you have to, until you beat this case. But you want that on record so that there's no way they can say when they get down there, oh, Ty Tucker they took him into jail and he became despondent and he killed himself. No, that's not even possible. And you want it to be clear the condition you went in. You want to have a medical examination, and you want to leave all that with, I don't know if you're in contact with your attorneys down there, but you make sure they have it all on file and ready to go so that it's released. If anything happens to you, it's immediately released to the press. It's immediately given to attorneys who will begin a fact-finding mission of finding out what happened and ready to sue for your wrongful death. Well, yeah, but the health issues though, but what I want to say is make sure that those are the only, like, all the health issues are documented, right? So that there's nothing life-threatening right now that currently would off you, so they can't just all of a sudden 5 days from now say, oh, he came in and this happened. Well, Dolores, he passed the urinalysis, just so you know. I mean, like, this is not about failing a urinalysis. He actually passed the urinalysis. Do I? No, what could be a problem, Ty? What could be a problem? Do I think that the judge would react the same to Ty pro se as to a lawyer acting for him? No, I listen. My dad will tell you, and my dad has said this to many times, because again, I haven't got into the story of my dad, but I have myself experience with watching how judges react to pro se defendants versus attorneys. They treat them very differently. This judge will feel like he can get away with a lot more because Ty is pro se than if an attorney was standing in there. Now, it doesn't mean that they won't try to be, biased in ways, but they won't be as egregious. They won't be as willing to test their limits or do certain things because they're going to feel like, well, this individual's not going to know what's happening. He's not going to know that this is against the rules. But yeah, Ty, what could be a problem? What could be a problem, man? Are you talking about the urinalysis, or are you talking about your health issues? I assume you're talking about your health issues. Because to me, 5 hernias. Well, you just want it all documented. The reason why I'm saying is you want it all documented so that they can't say what's happening, what's going on. And you just want to do all of that. That protects you. But the most important thing is you want to protect your mental. You want to show you're not in any way suicidal. And then if you do have medical problems, you want to make sure that you're going to get care for those medical issues and conditions. So there's anything going in on it. But you should. But man, 5 hernias. That's, gosh. Have you had 5 surgeries on them, or that's? Oof. My mom has a hernia right now, and she's not getting it. It doesn't require to be operated on or anything. But man, I know that is not fun to live with. But these are just things you want to do just to make sure you're protected. Make sure that there's nobody that could say anything, and lock it up, and provide as much as you can. But that's what I would say. You want to show up down there ready to go. I'm not trying to avoid this thing. And if there is medical stuff, that would be one reason why you might ask the judge to let you out on bond, keep you out on bond. I mean, if you're getting treatment for medical problems, but perhaps this judge won't care. I don't know. But it's certainly a valid issue and concern. Oh, wow. I got you. Well, I know you're not going to get adequate medical care when you get when you go to jail. Yeah, you're darn right on that. It's not going to be good. But that's why you want to have your medical history documented. Make sure you can provide all that. Well, that's what I mean. I don't anticipate he's going to. That's why I'm saying I don't think he's going to be afraid when you go to the press or anything like that. He's moving. I mean, maybe it might give him a little pause, but this is what they want. This is what they want to do. My opinion is this. They want to hamper your ability to defend yourself if you're going to go pro se. And they're figuring if you're going to continue, this is his version of saying, I believe this is a way to deal with the gag situation. They won't necessarily need to issue a gag order because you won't be out there. So this judge gets to stay away from that because I don't think he necessarily wants to reinstate that. But I think he wants to lock you up. I think he knows that's going to limit your ability to get people like Todd O'Quinn in and everything like that. You're not going to have any ability to do any of that. I mean, unless you have somebody that comes out, but Lauren's already said she doesn't want to go down to Key West, so she's not going to be able to help you. Otherwise, you're going to have to hire someone out here to be doing that stuff. But if they're not an attorney that's hiring you, there's no attorney-client privilege, so that person could be subpoenaed as a witness. And then, the phones or the letters, yeah, but they're not worried about probably that as much as, you won't be able to be on YouTube anymore. You won't be able to be talking to people anymore. But yeah, they may still issue the gag. You're right. That would be, that may still come through. But they're going to figure that if you're still trying to defend yourself, on your own, it's going to be unsuccessful. So you're going to show back up. We're going to have the same show trial that they're going to have before. This time they're going to try to use the knife information. They're going to bring you in. This judge is going to shut you down every way to Sunday. He's going to give you zero leeway. And you're going to be trying to manage all this from a jail cell. It's going to be impossible to do it. And it's going to give them the advantage that they want or that they need because they don't have evidence, which is why if you do get locked up, whatever needs to be done to get an attorney involved, you've got to have an attorney involved at that point. Whatever's got to be done. I mean, and you've got incredible currency in the fact that your case has notoriety. Well, no, but Court TV is the one that you're correct. Court TV is the one that got them worried. Vinny Politan's the one that got them worried, which is why you've got to get in communication with Vinny. But what I'm saying is if you go to trial, and you're not going to be able to adequately prepare your defense from a jail cell. It's just not going to happen. It's going to be impossible. It's just not going to happen. It's just not going to happen. So you've got to get an attorney. Well, Sarah, I think that what we're talking about right now is not necessarily, I don't think, anything that is too. I mean, in my opinion, damaging in any way. We're just talking about, and YouTube is huge. So I mean, I think they're worried about YouTube because, they're worried about the lives that he's doing. But I think what they're worried about is that people like Court TV can go back to YouTube and go back to these places. And as more people, bigger channels and bigger people and bigger entities get involved, well, yeah, but see, the thing is, Ty, is, with you not being able to talk to Court TV now, they're going to feel emboldened as if that's going to be, because remember, the way Mansfield's selling himself is he was really disturbed that you would go out and talk to Court TV at the end of every day, right? And you were talking and you were giving Vinny Politan sound bites, and they feel like now Court TV is going to show Ty Tucker being led back to the Monroe County Detention Center. That's what they're going to see. That's what their goal is here. So you've got to, unfortunately, if they go through with locking you up, the way out is going to have to be, the way they're going to have to go, you're going to have to do is you got to get the jury to acquit you. That's going to be your way out. But the other thing they're also hoping, Ty, is they're hoping that when they put you back in there, expect it's going to be hell on earth. Because I think the other thing they're trying to do right now, what they desperately want to happen, is you to take a plea. And they want you to take a no contest plea. Because that's how they solve this. That's how they really solve this problem. Because you take a no contest plea, you don't have to admit your guilt. And in their eyes, you've still pled guilty, though, as anybody else would look at it. And therefore, you give up any ability to sue them or cause them any more problems. They walk away, you walk away, and it ends in the way they want it to end. Because they know you're not guilty. They have to. They're not an idiot. They know you're not guilty. But they also know that it's their ass on the line. And they can't let you just, in the worst case scenario for them is you're found not guilty. This thing never goes away. But they can't dismiss it outright, because then it definitely doesn't go away, because then you're going to do the same thing you do if it's not guilty. You're going to pursue them. So the only thing they can do now is either convict you and then they win, and then I'm sure some of them at some level will struggle to sleep at night. But when you get back in there, I expect this ain't going to be like the first time. I mean, they're going to do everything they can to make it the worst experience possible, which is, again, why you must have counsel ready to go to fight this thing for you on your behalf, to do everything they can do to monitor the situation. Be aware, file things with the court, file emergency motions if they have to. But that's why I don't necessarily think they're going to go right to let's off Ty Tucker. But could that down the road happen if maybe you're completely unwilling and you're going to press a trial that they don't think they can win? Maybe. But what we have to hope is that doesn't happen. But at some level too, like I said, attorneys have to, maybe, again, an attorney can absolutely help with this bail situation because this is garbage what they're trying to lock you up on. It's absolutely garbage. But it's scary, because the thing about it is, Ty, everybody's got to understand here, and this is the part that I think sometimes gets lost, especially with people on YouTube. Most of the time we see these people, they're on TV, they're behind bars, they're away from us, but you're a real human being who's getting affected by this. We're all talking about all the possibilities. You're the one that's going to be experiencing all this. This is horrific. This is horrific. And for somebody who's innocent, who's been going through this for 7 years, this is just crazy. This is absolutely crazy. Well, that's what exactly, T.S. Jackson. That's exactly what they're doing. 110%. Well, I know you won't, Ty. I know you won't. But I mean, like I said, if at some stage, just so you know, man, if at some stage, because of the circumstances you're faced with, you decided I'm going to take an Alford plea, and I got to end this. And I would not believe in your innocence any less. I'll let you know that. So just so you know, man, I understand the nuances of the law, and I understand that jail is a real thing, and I understand that what you're going to experience in there is going to be that it's going to be horrible. But if you decided that you wanted to do something like that, I would still continue to fight and still speak of your innocence, and it is what you got to do, man. You got to do what you got to do. There's still, but it is what it is, man. In terms of like doing what, I don't know though. Have you looked into whether or not you could still pursue, like if you did an Alford plea that didn't involve any jail, or no contest, would you still be able to legally pursue those, suing them and holding them accountable? I mean, I think you still could, because you haven't legally admitted anything. I mean, you're just saying, hey, they could potentially prove the case. I understand, it's like you're just saying, I'm not admitting innocence, or I'm not admitting guilt, and they're saying I did it. But like I said, you got to do what you got to do at the end of the day. I didn't think so. I figured you probably could. But listen, man, you got, at the end of the day, when you're in there and experiencing, I'm just saying to you, we're going to keep the fight up no matter what. I would not, I would not believe in your innocence any less. But I think it speaks volumes that you're unwilling to do so. I think it speaks volumes that you're willing to keep the fight up, that you're willing to risk your life. You know, I would imagine. Well, right. The suit. The reason why I bring up the suing is because the suing would be the way it would lead the Justice Department from potentially entering the case when you can bring the lawsuit and potentially remember one of the purposes of a lawsuit isn't always to get money. It's the ability to go through discovery. It's the ability to use the deposition power, subpoena power to get records, to put people under oath and question them. And you would be able to do that. Now they would, and then if they chose to take the fifth and not talk to you, you know, that ain't going to look good. And if you've got a Justice Department that's looking at this thing and saying, "Ooh, what's going on here?" You know, that would be something that could lead to these people finding their way into prison. You know, but you know, listen, my point is like, you know, you've got to consider all your options, you know, at some point. And again, if for some reason financially getting an attorney involved isn't going to happen, and it's looking like, you know, and it's just absolutely hell on earth in there, you know, you may have to consider at some point making a legal maneuver, so to speak. But, you know, it's just not, no, this is just a terrible situation. It's a terrible situation. But I'm telling you, you got to get an attorney involved. I still stand by that. Oh, I know. I listen. I guarantee you are. I know you are, Ty. I know you are. I mean, I know you're thinking of everything. I'm sure you are. I mean, you know, you're the one that's going to pay the piper in all of this because you're the one that's living with the consequences. All we can do is help suggest, you know, but that's why I'm saying, you know, in the end, the reality of this thing, which you've already experienced, obviously, so you know a large part of the reality. I mean, you're experienced with it, but you know, at some stage, you know, it's like, well, yeah, pro bono, somebody who would do it pro bono or court appointed, but a court appointed requires you to have, you know, to be in a financial position that you need court appointed counsel. I don't think Ty would qualify for that. Well, yeah, absolutely, and that's why I said, Ty, you're in a different scenario than you were 7 years ago, 1 year ago, 5 years ago, 3 years ago. You accomplished all that in January. So if there is a ability in a way to get an attorney in back involved in this thing, you're in a different position. You've got your ground crew. You've got people that are willing to speak and put things out. I mean, oh, I know you did. I mean, listen, I at trial, you had no. I don't think anybody really was, at least not on a major way, aware of the situation and everything. I know I wasn't. I mean, I remember when I was, you know, just getting into the trial, watching and all that stuff, and trying to figure it out. You know, and your trial came up. I'd been watching another trial out of Michigan, and your trial came up, and I was actually getting ready to go to Vegas. So I was kind of for a little vacation, and I got involved and said, well, you know what? This is an interesting case. And I got involved in day one. And little did you know, Ty Tucker, but I took you to, I actually was broadcasting your trial while I was there on Vegas. So I was sitting there because I was in the West Coast. I think you ended up flying through there. But my wife, she was very understanding because I got so into the case, and I'm talking with my dad. I'm like spending my days. I said, we're going to be in the hotel room watching the trial, and then we'll go out. And luckily, due to the time frame and time change, it was like 2 PM when your trial went in. So I was like, we got to do that. And I mean, I'm sitting up in the hotel room. She's yelling at me because I'm broadcasting live and putting together stuff. And she was like, she understood it, because she knew as I'm explaining it to her and saying, this is a crazy case. I got to get, I love Vegas too, man. We love it. It's a fun town. But that's where I was there taking it in. And of course we were flying back home, and I mean, we're driving down to the airport. That's when I was listening to John Travis Johnson's, witness statements. As soon as we got into Vegas, I'm setting up my computer and my equipment and watching it, and spent the first evening, went out, got a bite to eat, had a little fun, and came back. And I said, all right, I got to watch the rest of the trial. I'm in there broadcasting it live in the hotel room. And she's just like, I understand. I know and I'm talking to my dad and calling him up, and I'm trying to, this case is crazy. I can't believe this. So, but no, yeah, again, that's why I say we started out, I hadn't even heard of this case. And then I come back and I'm like, man, boom, come back in. And it was just like, as I looked into it and got deeper into this thing, I'm like, wow, this is a true situation where we have a factually innocent. Well, no, I kind of, I figured, as I was, at first I was a little skeptical as you were telling me all these different things, and I'm going, but because of what I knew about the legal system, and because of who my dad was and what I witnessed being his son, and the experience I had with growing up, and it was like I knew, I kind of was like, it sounds crazy, but I believe this could be true. So I was just like, man, we started looking into it, and I started talking, and I'm like, man, this is some real stuff. This is, as I started researching and verifying and watching, and then that's when I just got taken in, and I'm like, oh, this is, I took, like I said, I came back from that trip, and I was like, I think that Sunday I was putting out, I spent the entire day quarantined off on the side of the house and telling everybody, I'm working on something important, putting these videos together. And was, not worrying about going out and working or nothing. It was, like I said, I got taken in by it. But the point is, we're all in this, absolutely. I agree. I concur, Sarah. So, it's just, like I said, I think it was great you had the courage to go into court, and I have mad respect for that, because, like I said, again, well, I keep referencing my dad, but hold on, let me show you all something here. I'll pull this up so you. All right, let me show you something here. And this is why I had. Yes, well, because I was driving around, man, listening to that as I was out working and doing different things. I was listening to the whole. When I found your website, I was like, "This is great," and I'm just listening and listening. I was driving down the road when I heard that, and I had to pull off the road because I'm like, "Wait a minute, I can't believe I found this." Wait a minute, there's news articles out, Dolores. Oh, I was going to say, I didn't think I saw anything. I was just looking stuff up. But anyways, okay, let me pull this up, what I was going to pull up here. Okay, hold on. All right, let me share this thing here. Share this tab. And here we go. All right, so let me share this article with you guys. This is about my dad. This kind of gives some history that we haven't got into, but I figure I will share it. So it says here, in what may be a legal first in West Virginia, a person has been criminally convicted for the unauthorized practice of law. Berkeley Circuit Judge Gina Groh on May 12th found Stephen M. Askin guilty on the 11 counts of practicing law without a license, for which he was indicted in February 2009, according to the Hagerstown, Maryland Herald Mail. Groh issued her decision in a 46-page order following a 2-day bench trial in November. Ironically, Askin, 62, practiced law for 23 years until he was disbarred by the state Supreme Court in 1998. His disbarment came following his conviction for criminal contempt. Records show in May 1994, Askin refused to obey U.S. District Judge Irene B. Keeley's order that he testify in drug trials of 4 defendants, two of whom were his clients. Askin refused on the grounds that federal investigators obtained information through improper wiretaps contrary to the Fourth Amendment, and that any conversation between he and 2 of the defendants was protected under attorney-client privilege. After he exhausted his appeals attempting to quash the subpoena to testify, Askin pled guilty to a charge of criminal contempt on May 22, 1995. He was sentenced to 7 months in prison, which he served at the Federal Correctional Institute in Cumberland, Maryland. Records show prior to his sentencing in January 1996, Askin voluntarily surrendered his license and began to close his practice. The annulment of his license was made retroactive to January 30th, 1996. Breaking new ground. In speaking with the West Virginia Record, Askin said he intends to appeal Groh's decision. Research he's conducted on the statute prohibiting UPL on practicing unlicensed practice of law shows since its enactment in 1923, nobody has ever been criminally convicted. According to reading of the statute, Askin said the only time someone can be convicted for UPL is if the person portrays himself to be a lawyer, including arguing a case in a court of law on behalf of someone else and charging for services. Since his disbarment, Askin says he's done none of that. Instead, Askin admitted that over the years, he's helped people draft documents that they later file pro se. All those he's helped, Askin said, have been people he's known and have approached him. Also, Askin admitted that what he did is potentially UPL. However, he said the statute only provides for administrative and not criminal sanctions to be applied for his actions. A legal disruption. According to Askin, he was first accused of UPL in 2006 when he applied to have his license reinstated. His intent was not to actually practice law, but just to say he was a member in good standing with the state bar. Before the court could rule on his disbarment or could rule on his reinstatement, it received word of a potential UPL complaint, which it referred to the bar's UPL committee. A year later, the committee found no substance to the complaint. In 2008, Askin said he again petitioned the court to reinstate his license. The only person to oppose it was Berkeley County Prosecutor Pamela Jean Games Neely. The reason for her opposition, Askin said, was that she was fearful that he would be training young lawyers to disrupt the legal system like he did when he was a criminal defense attorney. It is no coincidence, Askin said, that he was indicted for UPL last year as the court, again, was mulling his petition for reinstatement of his license. If anybody is disrupting anything, it's Games Neely from the working class getting justice, Askin said. The prosecution was getting mad because I was helping people go to court pro se and beat the system, Askin said. The fact that the Supreme Court has never addressed a criminal UPL conviction is part of the reason he intends to file an appeal. Should they uphold the conviction, I'll deal with it. In the meantime, Askin is scheduled to be sentenced on June 24th, and he faces a fine of up to $1,000 on for each count. So I share that because, again, what my dad did for many, many years was helping people pro se go into court and beat the system with his help and his assistance. So Ty, you're only being tested for alcohol. That's what they're worried about. Yes, he was, Ty. I agree. I agree. But he was that was what, like I said, he spent his time fighting and fighting and fighting. And like I said, he was, so that's why I say, I know when the system comes at you, you can beat the system. But getting a lawyer to do so, or having a lawyer there to help walk you through, absolutely. Yeah. A lot of those tests are, especially, I guess, for, you're talking about for the alcohol test. I think I did the research after Ty was telling me. He's correct. It's only like 70% accurate. And it's not even correct. But why are they worried about alcohol, Ty? I mean, like, why does that have a factor in this? But they're not testing you for other drugs. Why is alcohol such a problem? You're not charged with DUI. It makes no sense. Makes no sense whatsoever. It makes no sense whatsoever. Well, absolutely. You will win, But ask the judge. Yeah, I know. It makes no sense. But you just got to stay positive, Ty. You got to stay positive, and well, I've beaten this drum. So have many others with you, talking about what we expect. But if you should decide, I just feel like it really stacks the deck against you if they lock you up. Now, if you stay out and you're able to stay out on bond, I think you got a good shot of being able to prepare your case adequately. Were you required to leave the state? Like, were you required to not stay in Florida? Is that why you ended up going to Oregon? Wow, I didn't know that. I did not know that. No, it doesn't make any sense whatsoever that you would be required to leave. No, that makes no sense at all. Wow, that is crazy. I didn't realize that. I thought you just chose to live there because that was where, like, Lauren was and everything, and you requested to live there. I didn't realize they actually said, "Hey, part of your bond is you got to leave the state, not be in Florida." I mean, it really doesn't, because it's just crazy. So you were required to find somewhere to reside that was not in the state. Makes no sense at all. It really doesn't. It makes no sense at all. Normally, they'd want you in the community so you could go to court, show up in court, so that pretrial would be able to, do things conveniently, and make sure that you're dealing with all their people, and you need to go do a test or something, you can do it right there in state. Wow. Mm-mm. Wow. Well, so I guess, Ty, when you know something, I guess you'll know something this morning then at some point when court opens. We'll see if this warrant actually hits the hits the wire. And then I guess we're fine now, man. But so, you know, I don't know. Wow. I know this is crazy, man. I really, I just, I can't believe it. So no problem. Ty was finally able to get the thing you sent me open. I don't know why it wasn't opening earlier, but I finally was able to get it, and I saw the screenshot of the emails there. So yeah, the email, the thing you sent me that was the screenshot of the email. It finally, I don't know why it wasn't allowing me to open, but now it finally is. I could see the conversation you sent me. It's not for testing on 410. You're late on 49. Well, so at this particular point, though, the warrant is. He says, "Is that your guy? The guy you were talking to there, Ty? Is that the guy? I guess that's your pretrial guy?" And I guess he was just. Yeah, no, I saw the transcript. I'm just saying the guy that's in the transcript. Oh, the transcript. Oh, yes, I have that up actually here. I've got a no, his assistant. I got you. Yes, I have the transcript up actually over here. I've got to read through it. I was going to put it up and read it to everybody, but then I thought, well, I need to read it first just to go through and familiarize myself with it so I can pick out the pertinent facts. I got you. So his assistant, that's his assistant. So at this point, you've not gotten any official confirmation from the judge then that any of this has gone down. Just that, oh, he passed you off to the assistant. I got you because he didn't want to deal with you for to tell you the bad news. Wow. How stand up is that, right? Good night, man. That's crazy. It's crazy. But well, rest assured, man, we will definitely be, regardless of what happens, if you end up back inside, we will keep fighting, man. Well, I'm sure. Well, again, remember before now. Remember this, Ty. Remember this. He said he had the warrant already prepared once before, and he said the ink had dried. He just hadn't signed it yet. So the question is, if he clearly hasn't signed that warrant yet, because if he signed the warrant, it would be filed already. So I'm wondering if that was like a warning to you, to allow you to try to, explain or whatnot. That's why I was saying, if you have some attorneys down there who can reach out or figure something out or try to explain something on your behalf, that would be very helpful to get them involved. So, obviously, I hope that when you emailed the judge earlier today, Ty, I'm assuming you explained everything that you just, like I've seen you explain to me and saw explaining in that email, because it makes no sense that, they would revoke you that's crazy. That's why I said, like, this guy's got to be looking to, this is a setup of some sort. I mean, this is crazy to revoke your bond over being late. I mean, you didn't skip it. You still took it. You passed it. That's just nuts to me. It's just crazy. But I guess we shall see. But well, I think being the time of night it is right now, it's 5 a.m. where I'm at. So I obviously was on here a lot longer than I expected, but I'm glad I was on here because I'm glad I was got to talk to Ty here and talk to everybody. Hopefully, Ty, we can talk again here, because hopefully that means you're not locked up. And we will have another chance. And I hope, the judge does the right thing here. I hope that the judge reconsiders this, reconsiders the optics of the situation, and doesn't go through with this warrant. But if he does, we're going to keep up the fight. Don't worry about that, man. Absolutely. Well, I know you do, man. Hopefully you get those motions filed in before you go, if that has to happen, because I will be reading those and getting out all the information in them. I'm looking forward to it. But we will continue to fight on, man. And hopefully we can get a win here on this with the judge. I hope he reconsiders, because this is some egregious stuff. This is some terrible stuff. But yeah. But But anyways, guys, so I appreciate everybody that tuned in. Ty, I appreciate you, man. Listen, I hope this isn't the last time we get to speak and chat. One of these times, one of these days, we're going to coordinate, and I'd like to have you up, and so we can actually talk on camera, face to face one time. When this is all said and done, it may have to wait till it's all over with, but at some stage, we're going to come up, talk, chat, and I hope talk about how great it is that talk about how bad this is, but also hopefully talk about the victory, man. And then eventually, maybe some stage, have a victory drink together somewhere. Maybe out in Vegas when all this is behind us. So keep fighting, man. Keep fighting. Don't give up. We're not going to give up. And just do the best you can, man. Appreciate you too as well, Dolores. Appreciate you, Sarah. Appreciate everybody in chat. If you can, hit the like button. Hopefully people will see this. and all the information that we put in it, because this judge is not going to get to hide. This judge does not get to come in here and carry Judge Jones water, because that's what he's doing, in my opinion. And if he's going to do it, he's going to do it in the open. He's going to do it with light shining on him, and he's going to get highlighted. So that's what's going to happen. Absolutely. All right, guys. Well, I've got to go and get a little bit of shut eye, because I got to be up in about 4 hours. So, and my wife will be getting up in like 20 minutes, and she'll be like, "What are you still doing awake?" But she understands. She knows. I was telling her all about this earlier this evening, so she knew. She knew it was very, very distressing. I was very distressed and upset over this when I found out about it. So, anyways, that's exactly right. All right, guys, I will talk to you soon. I appreciate you all. And, hopefully, as I always say at the end of all my lives, let justice prevail. But hopefully it does in this instance, and we get good news, and this judge decides to do the right thing. Anyways, guys, I'll be talking to you soon. And until then, let justice prevail. And Ty, I know this won't be the last time we talk, because this is going to work out. So good luck, man. If it is for a little while, good luck. Stay positive, and know we're supporting you, man.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast, I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains at last, and to believe in what you got, it was built to last, yeah.
Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Gonna learn the consequence of being incompetent. Mental health is confidence, dreams and some honestness. I'm not here to save the day, that's for you to take away. I could play a million mind games, but instead I say something not illogical, something that is topical. Rub it on and watch it go, make yourself unstoppable. Dreams are irresponsible, but they're always possible. If you just believe, you could be so remarkable.
Thoughts in my head, a collage and they spread. I'll be great one day, going off of my meds. No, I'm not giving up, no, I'm not giving in. I will make it to the top, taking off in the wind. I gotta make it, I'm saving every day to taste it. I'm patient, but my mind, it can hardly take it. I'm chasing a dream that I've had for several ages. A vacant, modern kingdom for the taking.
Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.